gentlemen, and well, in this small circle, my friends, because conferences are, we pretend to come to the conference for academic purposes, but frankly, we are in a small circle. It is being recorded, but one of the reasons is to visit nice places and meet old friends and also make some new ones. And I am very happy to see some familiar faces and also some new faces to come for this conference in Vienna in spite of all these difficulties. Many things are unusual, although I hesitate, I'm uncertain to say what is actually unusual now. When the pandemic started, the first online conferences, everybody started opening speech with the line, well, we are meeting in certain unusual circumstances. And since we are meeting on site physically here over this last 2 years, physical encounters became something unusual. So this is a very unusual event that we are fortunate to meet here in Vienna physically. When we started designing the very idea of the conference last year, because we are in the Polish Academy of Sciences and everything needs to be planned way in advance, we were naive to believe that maybe in the second half of the year the pandemic will somehow be under control, and I will have a privilege to address these first lines to a big audience of lawyers and academics interested in adjudicating and resolving corporate disputes and disputes related to capital market. Instead, we are in a very small familiar circle, but we will try to make the best use out of this. And I think the chances that we'll have a learned discussion in the circle of experts. Another thing that is unusual about this encounter is that it is a 2-day conference, but unlike all the other 2-day conferences, it does not go for 2 days in a row. The first day we had exactly 1 week ago, and we continue today. The first day was only online, and now we have this on-site meeting, but during this 1 week time span, 2 of the speakers decided to move online. So we will need to manage this somehow, this challenge of combining on-site and online conferences. 2 of the speakers are scheduled to speak remotely. Now, one awkward thing for me is, since this is a 2-day conference, 2 formats and 1 week time span, so I am in an awkward position of delivering 2 opening speeches, which is a challenge I don't want to repeat myself too much. But still, since the participants are not exactly the same, and some will join us later, just a very brief reminder and how it all started. I'm fortunate to wear more than one hat, and in my former life, which actually continues in a more discreet way, for many years I worked as the president of the Ireland Institute, which is a legal think tank based in Krakow. And well, as some of you here in the room, I confirm I have my good friends Ariel and Marcin, with whom I have worked at the Ireland Institute for a long time. We have a fair track record of working on different reform proposals, policy documents, draft legislation, and other advisory for policymakers. And so we sometimes call ourselves like reform ninjas in different areas. And we were approached, I think it was 2015, by the Warsaw Stock Exchange to design how a capital market court could look like in Poland. It was back then a very early stage process. The idea came up to as a part of capital market agenda. One of the steps was to improve enforcement. And so I worked on this with a couple of colleagues. One of them was a speaker last Friday, and we came up with a proposal. Frankly, not very much has changed ever since. It was 2017, not 15. But the discussion at least started, and this has been steered. Maybe the government had other priorities over the time, but the idea is still alive and it's still being discussed in different circles. And this is one of the circles that I'm very much looking forward to discuss in a very comparative way, because there's different experiences. And while capital market law and financial law over time has been harmonized, if not unified, to a large extent in Europe, to a lesser extent, but also there is some successful harmonization when it comes to company law. The infrastructure for law enforcement remains very diversified, which offers some chances and limitations. We have some competition. We also might have a chance to exchange ideas, and this is precisely why we come here together to exchange our ideas, what we have in our countries, what experiences we have made, and what ideas we play with, how we can improve our law enforcement in our respective countries. Some of the countries are far more advanced than others when it comes to specialization. We had a very interesting talk last Friday by our colleague from the Netherlands about the Dutch Enterprise Chamber. We will have, hopefully, if we overcome the technical difficulties, a speech from Israel. Israel has now more than 10 years of experience with a specialized business court that is modeled after Delaware Chancery Court. Some other countries have other experiences, maybe less advanced, and we will try to discuss pros and cons of judicial specialization. I mentioned some of them 1 week ago. I don't want to repeat them. We will have them raised by the speech that will be on our opening keynote address by Professor Wiener, who will frame the topic and, well, make a ground for our more detailed discussion. If we look at the agenda, we have very promising presentations. Some of them are empirical studies, and I think we lawyers, it is never enough of empirical studies, so I'm very much looking forward to listening to them and then to discuss with you. Since we started a little bit late, I will now come to an end, and please let me introduce our keynote speaker. I already mentioned, Professor Martin Wiener, a good friend of mine for many years. I'm privileged. We have worked also together for the European Commission and the ICLIC group, but this is just one of many Martin's international commitments. He has an extremely long track record of advising European institutions on company law, in more official, less official, all very influential, has actual impact on what we are having in Europe when it comes to legislation. But also he is a professor at the Wirtschaftsuniversität here in Vienna, the director of Research Institute of Central and Eastern European Business Law, FOVI, which also has a good track record of advising reform countries to modernize their business law. Martin's expertise is in company law and also securities regulation and M&A, obviously. He's editor of the leading Austrian journal Zeitschrift für Finanzmarktrecht, and last but not least, chairman of the Austrian Takeover Commission. Austria has, some countries have, as Poland, a centralized body. Austria has a special body supervising takeovers, and this is the person who has chaired for a long time this commission. So Martin, we are extremely happy and privileged to partner with you personally and also institutionally with Wirtschaftsuniversität. Thank you for being with us, and the floor is now yours. Thank you.
Thank you, Arek, for this extremely nice, flattering, and completely exaggerated welcome. Yes, ladies and gentlemen, my keynote speech has the big advantage that you do not have to give solutions, you can give impressions, and I will give impressions and I will give an overview. I will not talk about details. This is to a large extent academic, not completely. As Arek has mentioned, I've been with the takeover regulator for a long time, and so I will try and also give some insights into my experiences there. What will I do? I will start, if this works, and it does not. So anyway, what I will do is that I will start by giving an introduction into the topic. Then I will address some of the problems that generalist courts may encounter with specialized issues. Then next I will talk about specialized judges in order to, at the end, to address the issue of specialized institutions, that is specialized courts. So that is what we are going to do. So let me start with the introduction in the first place. Now the title is Specialized Courts, the title of my presentation. I elected it myself, so it's my fault. And specialization refers, of course, to specialized subject matter on the one hand, combined with subject matter expertise. But in reality, and when preparing the presentation, I noticed that it is two different topics. One topic is specialized judges, and the other topic is specialized institutions, and that is not the same as we perfectly well know in Austria. So I will deal with both of these issues in the following, and I will try. Probably the better title would have been judicial specialization, framing the topic, but that's not the one we had. Now let me start by addressing some of the problems we have very briefly. The first problem, of course, is lack of knowledge, namely lack of knowledge by the courts, and that refers both to the business knowledge and specialized legal knowledge. So it's little knowledge of the facts underlying the cases and little knowledge of the legal issues you have to know in order to solve these the problems. Both of these lead to dependence from, for instance, expert witnesses. We've had that topic last Friday here, a dependence from expert witnesses who, in theory, at least in our legal system, should only be experts on matters of fact, but in reality sometimes act as experts on matters of law as well. So lack of knowledge, which in a second step affects the quality of the decisions. Why? Lack of knowledge makes judges insecure. They try to avoid the hard issues of applicable law, substantive law, but they prefer applying areas of the law they are more familiar with. And this is typically procedural issues, whether judges are specialists, of course, and general issues of substantive law. And that means that very often, with lack of knowledge, you get formal decisions which do not really solve the matter at hand, which actually would be the main job of the judge, to solve the dispute. And they sometimes prolong the dispute instead of solving them. So, and more generally, of course, this low quality of judgment then, in a second step, results in a higher number of appeals, or more precisely, makes it more likely that appeals are successful, which then results in higher number of appeals by the parties. So this sort of comes back, and this also leads, as a third step, that the length of proceeding goes up. So individual proceedings are too slow due to lack of specialization and, in production, you would say, high setup costs. If the judge each and every time has to refresh his or her knowledge, this takes a long time and makes the process more cumbersome, which in turn leads to overcrowded court dockets and huge backlogs, which negatively also affect other cases, the more simple cases. So this sort of, as a loop back into more easier general cases, which also take longer. And if you combine that with especially complex issues and legislation for which courts and the regulations of their proceedings may not be ready, this means that that proceedings take too long. right? And this leads to two overarching problems. The first one is a legal environment which is not sufficiently secure. This is an issue if you want to attract investors, and especially foreign investors on the one hand, and if you want to foster domestic investors on the other. Both areas may be negatively affected, especially with capital market courts, which will sort of form the background of my presentation, but is not the precise topic of my presentation, only those capital market courts. I'm talking about specialized courts more in general. And the second one, of course, is that you may encounter some type of under-enforcement. So the issue is, do we have sufficient enforcement of issues which are in the public interest, such as investor protection? Of course, there may be additional problems, especially political issue, as far as the nomination of reliable judges is concerned, or the removal of other judges. In the following, I will generally, although not always, assume that such issues do not exist. In any case, they shall not be understood to form the background for my arguments. So let us turn to the first big block, namely the specialized judges. This, of course, is an old discussion of judicial specialization versus the generalist judge. And I will try to do it in 3 steps. First of all, I will try to address potential advantages, then potential disadvantages, and then finally to identify some success factors or critical factors when dealing with the issue. Let us start with the advantages. Well, in order to state the obvious, it is, of course, with specialized judges, easier to develop adequate knowledge, adequate expertise on the issues. And that can refer, again, both to factual, technical expertise and to legal expertise in a narrow sense. Both, of course, is important. Otherwise, there may be a need for more assistance in the research. And that assistance you can try to achieve by 3 ways, basically. The first one is in-court assistance, which is difficult to achieve in a legal system, which is focused on the individual judge. You may have that via, for instance, lay judges. Lay judges can help in providing especially factual expertise. But I will address that briefly at a later stage. Secondly, who can provide assistance? Well, obviously the parties to the case by the legal briefs. That is, of course, inefficient because it leads to lengthier and lengthier and lengthier briefs. If the lawyers think that they have to explain everything, this will drive up litigation costs to a large extent. And of course, it's dangerous as well because the parties are interested by definition. So reliance on the legal briefs of the parties may just lead the part who can write better to win the case, so to say. And then finally, of course, court experts. I've already addressed these issues. So lack of knowledge is one, or rather more knowledge is one potential advantage which sort of mitigates these issues. Higher quality of decisions. I've already addressed that, but just want to add that higher quality generally results in higher acceptance, and acceptance is the main fool any legal system runs on, acceptance of court decisions, which of course means fewer appeals, which also means a support for the higher courts in the system, because their workload will go down. Other advantage, improved efficiencies. The specialized judge is required to remain current on fewer fields of the law, and this will be true for the generalist judge as well, because it does not have to look at these specialist issues anymore, which means that fewer people need to expand resources to keep up to date, which translates into cost savings at the end of the day. Speed, fourth advantage. As the judicial officers or judges hear specialized cases, they are focusing on similar issues repeatedly, with the effect of decreasing the number of judge hours required to process such complex cases. In 3 words, hope for improvements in quality, speed, and cost. However, there are, as always, disadvantages, or at least potential disadvantages as well. Anyway, what are the potential disadvantages? One disadvantage is judicial isolation. If you remove judges totally from mainstream legal practice, this could mean that they do have a very narrow view of the topic. There is less intellectual flexibility and hence less readiness to deal with new issues. And that is the big advantage of the generalist judge, this intellectual flexibility. And it may also lead, specialization of judges, it may also lead to a tunnel vision. I think Professor Kodek last week has mentioned that in Austria, the tax courts are primarily, or the members, the judges of tax courts are primarily former officers in the tax administration. And this, of course, leads to a tunnel vision. A third issue, very important, is regulatory capture. This is an issue especially for commercial court, where there's sufficient resources expanded in order to try that. And let me remind you for the reasons for installing the early commercial courts with the merchants on the bench, the merchants themselves who were on the bench. The reason was, of course, the protection of the merchants' interests. So that means, and the specialization we are putting to the front today only came at a very late stage in the development of commercial court. That argument only came to the fore at a late stage. So now, why is this especially dangerous for specialized courts? Because on the one hand, the specialized lawyers or parties who appear regularly before the judges, and that may lead to some sort of cozy relationship between those lawyers on the one hand and the judge on the other. And as there is probably a closed group, then the judges may at the end share common values and a common outlook with their professional group, with their peers. And this, of course, may lead to a bias in adjudicating those cases. And this is, by the way, especially dangerous in non-adversarial proceedings, like the commercial register or the takeover commission, indeed. Because what the takeover commission also does is advise parties who present an offer whether some ideas they have are in line with takeover law. And there's no other party, there's no adversarial proceeding, and there's a huge danger of regulatory capture in such situations. So this is hugely increased. So, of course, whether these advantages or disadvantages can be realized, that depends very much on two factors. On the one hand, it depends on the nature of the field for which you try to achieve specialization. And from that point of view, I think the decision is largely a function of two factors, namely the complexity of the cases on the one hand. That is both factual complexity, think for instance cases of medical malpractice, or legal complexity, capital market law. It's also factually complex, but it's also a legal complex issue. And then that's on the one hand, that is the complexity, and on the other hand, the number of cases. The lower the number of cases, the less likely it is that a generalist judge will have to deal with these cases regularly. The more salient becomes the problem of the high cost of informing themselves. And that is a big argument for a specialized institution. So the combination of complex cases, complex issues, and few cases is generally speaks in favor of some sort of specialization and probably also centralization, to which I will come a bit later. So but then let's look at some of the success factors which should be addressed probably. First, of course, selection of judges. Selection of judges means that they have to have business knowledge, they have to be dynamic personalities. It's easier said than done, of course. So I think it is very important that you do not select the judges only from a narrow field of candidates. I've already made a reference to the tax courts here in Austria, which is probably not the optimal arrangement. So the important aim is to avoid a structural bias in the selection of the judges. And this has got something to do with selection procedure, But much has been said, and I do not have anything meaningful to add, to be honest. But it's also self-selection. It is also self-selection of the candidates who apply for a post in such a specialized, for such a specialized position. And for that self-selection, I think that various factors are very important. First of all, attractiveness of the field of law in question. Is this an attractive field of law? This is hugely important because people are intrinsically motivated and they want to do interesting things. Of course, it's also influence, so it must be high value cases are more attractive to dynamic judges, I think, than lower value cases. The second one is payment. This is quite obvious. But this is typically difficult to achieve in a judicial system because there's pay grades, there's a system, you don't want to go outside of that system. And it certainly is easier to achieve in specialized courts than if you do it with specialized judges within the general court systems. And the third one, and that I think is crucial, is to provide sufficient career perspectives. So a specialized court should not be a dead end for ambitious judges. Let us again think back to Professor Kodek's presentation a week ago, who actually said that Austrian judges in commercial courts generally have very good career perspectives, and that makes commercial courts also attractive in the Austrian legal system. Another thing is to address the issue of over-specialization of specialized judges. So that means, ideally, you should have sufficiently broad areas of the law to avoid that, to avoid mechanical processes. And it's also important as far as the just mentioned career opportunities for the judges are concerned. If the field isn't too narrow, they may not be considered adequate for other positions in the judicial system. The second issue, probably very important, is whether the assignment of judges to specialized position should be unlimited or for a limited period of time. Mind you, I'm not talking about tenure, whether tenure as such is limited or unlimited. I'm talking about the assignment of judges to that position. And I think it can be too long, because if this assignment is too long, this of course may lead to this mechanical application and routine, but it cannot be too short. It must be long enough in order to reap the harvest of specialization in the first place. And the balance is probably important, but I think that the period of assignment is an issue any legislator would have to think about when installing such a thing. It's also important, by the way, the time of assignment, to give flexibility. Should an area decline in practical importance? What do you do if you've got a court in place with unlimited assignments and then suddenly the caseload goes down? That's a huge problem for the financial system. So, and also, I think it is very important to achieve some sort of cross-fertilization between generalist judges on the one hand and specialist judges on the other. So there's various ways you can do that. You could, for instance, install specialized chambers, and in those specialized chambers there's a core of specialized judges, but there's also always a generalist judge also on that chamber who cooperates with the specialists. Or the other way around, you could include specialized judges to some extent on generalist panels. That is, by the way, the solution of the Austrian Supreme Court, where we do have a specialist panel on company law, a chamber for company law, but which also has to take up a number of cases of the general docket. So there's a specialization company law, but they do get other cases from all areas of the civil law for which there is no specialized chamber in the first place. Of course, that is much easier to achieve without a specialized court. It's much easier, much harder if there is a separate institution. Lay judges. I personally, I'm a great champion, a great supporter of lay judges, which is no surprise as I'm such a thing myself. But in general, my experience in takeovers has been very good with that, because they bring in expertise, they bring in practical knowledge, they bring another vision, another angle on the issue, and that is helpful. I do not believe in panels entirely composed of lay judges, but I think that they do have can have a very important function, especially in areas where you need factual expertise. That is the core issue, what they are good for. So I will stop there. I could go on. I could talk about the correct definition of the area of the area of law. I just want to mention that, of course, it is very hard to decide what precisely should be the subject matter for specialized judges, because you can do that by areas of the law, which brings a lot of boundary questions. Does it fit within the specialization, or does it lie outside? You could do it easily, like in Austria, in the commercial court, where it depends on the defendant in the case. If the defendant is an entrepreneur, that's an issue for commercial court. We've already heard that this means that the commercial courts are the biggest consumer courts in Austria, because the plaintiff doesn't matter. What sort of specialization do you really want to achieve? In Austria, I do not see what the type of specializations the commercial courts have, apart from managing complex cases. That's about it, but there's no legal specialization. So let me turn for the remaining, I think, 8 minutes or something like that, to the specialized institutions. Again, start with the advantages. If you, instead of specialized judges, also have a specialized court, this helps with a very important question, that is uniformity of decisions. And that is an important issue, consistency of application in the application of the law. And that is much easier with specialized courts, but also even easier if the specialized court is also centralized, if there is just one court. I think generally this more expertise will result in uniformity, and that uniformity, of course, obviously leads to less litigation in the long run. Not at the beginning, obviously, but in the long run you will have less litigation. And very importantly, it avoids forum shopping. Uniformity avoids forum shopping. I just give you an example from Austria, where the commercial courts are responsible for the register, for the commercial register, and this is the so-called Landesgericht, which is a lower court, basically one type of lower court, and there was the different practices in this area. So this led to companies changing their corporate seat in order to get into the jurisdiction of a court which was more lenient in their practice, or even changing the corporate name in order to change the judge responsible for the cases. And I think this is of course counterproductive, and I think not for the party in question who wants to achieve something, but for the system as such. And I think that uniformity is easier achieved that way, because otherwise uniformity must be achieved at the appellate level. And that is a more costly way and longer proceedings to achieve the uniformity. Increased system flexibility. If there's volatile caseloads, these volatile caseloads at least do not affect the general legal system, the general judicial system, but only affect that special court. And very importantly, specialized courts give the opportunity to make a fresh start. And this has various sub-factors, which I certainly will not mention all of them, but let's just look at 3. First of all, a specialist court starts with an empty court docket, which means it doesn't have any backlog. And that makes dealing with cases rapidly much easier, at least at the beginning. I mean, you're playing for time, but at the beginning, this fresh start, this empty docket, is a big advantage. It is easier to provide, in order to avoid backlogs, it is easier to provide adequate finance for a specialized court, because you do not have to finance the entire court system. You just have to provide finance for that court. So that is, I think, a huge practical advantage if it's a problem of funding. And last but by no means least, there are cultural factors. It is easier to install a culture in a new institution than to change the culture in an existing one. And I think that this is a major factor which may be important when installing new courts. Of course, there are disadvantages as well. Those disadvantages, probably at some stage, there may not be sufficient litigation for a specialized court. So what do you do then? Especially once the case law has developed. That may be the moment when there's more legal certainty, where parties are it is more easier for parties to ascertain in ex ante whether or what their legal position is, which may lead to less litigation. And there, a system of specialized courts is probably less flexible than just specialized judges in the generalist system. There's a higher danger of political influence in a commercial court, in a specialized court, sorry. There's a higher danger of regulatory capture by the parties which are involved, especially in judicial appointments. Regulatory capture as far as the appointments are concerned in a generalist system doesn't make a lot of sense because you don't know where to capture, so to say. This is much easier where the court is specialized. Of course, judicial isolation will be more pronounced in a specialized court than if it's just a specialized judge in the normal court system. So all the issues with isolation are probably more important. There's a public access issue. Public access to the judicial system, especially if it's combined with a high degree of centralization and a large territory. So if you see, for instance, capital market courts, and you just have one capital market court in Warsaw, in Krakow, or wherever, then is this an issue for as far as access to justice is concerned? It is probably not an issue if just the merchants, if just the entrepreneurs if it's just for cases between the entrepreneurs, because for them probably it's not an issue to go to Warsaw. But as soon as this capital market court also deals with consumer issue, that is consumer against issuers, for instance, then of course the access to justice issue becomes more important. Obviously, large centralization may impair access. Important also is that generalist courts may be more unattractive to the best candidates for judges, especially if there's no career opportunities, if you're stuck in the specialized system and can't advance past a certain stage. I think that is dangerous, and it may be dangerous the other way around as well. It may be dangerous that all the attractive fields of law go to specialist courts, and you do not get good candidates for the generalist court. That may happen as well. So I think you have to bear, as a legislator, you would have to bear those factors in mind. And finally, there's an easy issue, the multiplication of facilities if you have separate courts. You need more libraries, you need more IT departments, and so on. So this can drive up the cost of the judicial system as a whole. Last, let us look at some success factors in this context as well. I will just skip most of them, just mention 2 or 3. I think it is very important, first of all, to make the system as flexible as possible, but without endangering judicial independence. So again, you've got to weigh those factors. So flexible, what happens if the caseload goes down? How would you deal with that? Did you really define the area that there is a sufficient caseload? Also in the long run, what are your expectations? What may happen in 10 years' time? I think that is important, and if you have doubts there, as far as sustainability of a court is concerned, then probably it's a good idea to go for a less drastic solution, probably to introduce specialized judges in the existing court system. Yes. And then, of course, last point, the important issue is at which level should specialization end? Should you just do it in the first instance court, at the trial level? That is probably a good solution if the issue is factual expertise. Then the trial level, specialization at the trial level may be sufficient. Of course, and also let us not forget that review of the decisions by a specialized court by generalist judges helps to avoid issues such as regulatory capture. So this is an important counterbalance to regulatory capture or to the danger of such effects. But of course, if the issue in case is the uniform interpretation application of the law, if the law is complex, then there may be good arguments to take measures at appellate level as well. Or probably you could also think about a mixed system, where the lower courts are specialized, but appellate courts operate in chambers which are both specialized in certain fields of the law and have generalist responsibilities as well. This again is the Austrian system. I'm not advocating it, I'm just saying it is one one way to balance these different issues. So I could go on and go on, or one could go on if one had more expertise than I do, but that is probably some of the main issues. It was just a brief overview of some of the core features in the discussion I gave to you. And of course, I did not address the issue what this means for capital market courts, especially in Poland, and that is up for our discussion of a further presentation, both here today and in other venues, and of course discussions which may just inspire the legislator one day. Anyway, in any case, I thank you very much for your attention.
Thank you very much, Martin. Nicht bewegen. Działa? Thank you so much, Martin. Well, techniques sometimes, is overwhelming. Thank you for setting the stage for the discussion today. I would like to ask you to remain with us, and we will have a discussion jointly after the first panel. And when I was listening to you, I suddenly realized how happy I am not to be a judge, because you mentioned this cozy relationship. And I happen to have a very cozy relationship with some of the speakers also for the first panel. And I would like to invite to join us here our speakers. Initially, we wanted to have everyone in person, but due to the pandemic circumstances, Professor Roy Shapira couldn't join us physically, and we will try to connect him remotely. But the other speakers of the panel we have physically with us, so I would like to invite Christoph Diereger to join the panel, and Marcin Mazgaj to do so as well. Robert, jesteśmy gotowi na połączenie, czy nie? Zdalne? Czy na koniec dać to? Okay, so we will start with our speakers who are physically present, and then we will still be struggling with the remote connection. So please let me introduce our first speaker, my colleague for a couple of years now, Dr. Christoph Diereger, who is one of the leading attorneys in Austria in the field of M&A, both private and public, including hostile takeovers in Vienna Stock Exchange. Some of them work together also. Christoph began his career at the university, at the Wirtschaftsuniversität, as assistant professor. He then headed an office at the Austrian Takeover Commission. Then he moved to private practice, and today he is a partner at the established renowned law firm based in Vienna, Dorwald Zeiss Zocklich, Rechtsanwälte GmbH. And as I mentioned, his fields of expertise embrace corporate law, M&A, capital market securities regulations, and so on. And he is also sharing his knowledge with students, lecturing at the Wirtschaftsuniversität Wien, and also through publication. And Christoph will share with us his hands-on experience with disputes, mostly about M&A and corporate matters, and what is the role of specialization there. So, Christoph, I'm extremely glad to have you here with us. So please, the floor is yours.
Thank you very much.
I guess 15 or 20 minutes, let me double check. So I think between 15 and 20 minutes should be fine, if it is okay.
Okay. Thank you very much for the kind invitation, and thank you very much, Martin, for this wonderful introduction to today's seminar. I would like to speak to you about procedural acceleration, specialization, and legal unity versus legal control and separation of powers. That's a very long title, and we'll try to let you know what this is meaning. When we talk about specialized courts in the field of capital market law, we are focusing on courts, but the courts are not the only governmental bodies involved in the enforcement of capital market law. There are more. And I would like also to draw your attention that when we design the enforcement in the capital market law, we have also to bear in mind that any government or any nation is not free to structure this enforcement. We have restrictions in terms of constitutional law, and we have restrictions in terms of human rights, and this impacts the whole system a lot. Before I start with my thoughts to that, I would like to remind us what is so special about capital market law that we really need a specialization, or we are talking about these topics. The first feature I would see is the capital market is a very anonymity anonymity in the capital market law. We have intransparency on the market practices, and we have also intransparency on the market participant. This leads to the fact that it is very hard to disclose the whole relevant circumstances, and also if there have been a breach of law. Then we have a multinational problem with multinational investors and multinational market participants. I can go to mask. Furthermore, we have also the problem with rational apathy of the investors. It might make no sense for individual investors to enforce their claims due to high legal expenses. So this leads to one request, that we do need governmental oversight and official prosecutors on a multinational basis to enforce capital market law. The second specific feature is that if we have an infringement of capital market law, the effects are potentially multiplied, and there are mass effects, meaning that many investors are in the same position, so that comparable legal proceedings could accumulate. This could lead to high economic enforcement costs, could also harm the effectiveness and unity of the legal system. So therefore, we do need, whenever possible, decisions that are also binding on third parties in order to reduce legal costs for investors and avoid conflicting decisions. What are the possible legal instruments, how we could cope with this special feature of capital market law? One could be a model procedure with erga omnes effect, so that we have only one proceeding deciding the case in a very basic way, or preliminary ruling procedures with binding effect to third parties, or at least class actions or something like that. That would facilitate the enforcement and would help to lower enforcement costs for all parties. Further specific feature of capital market law would be that capital market law is a special law characterized by high economic relevance and great economic specialization. And furthermore, we have intertemporal impermanence of the market and short-livedness. What do I mean with this? The market is going very fast. The circumstances, share prices go up very quickly and fall very quickly as well. Investors come in and go out of shares. And therefore, we have, on the one hand, there could be an investor who immediately after the sale of the shares stop monitoring the relevant title listed at the stock exchange, so that they are not even aware that they could claim for damages. And they are too late when they became aware of some wrongdoings on the capital market, they are time-barred, for example. That's the one side of the investor, that's the risk, that they are not even aware that they can claim for something. And on the other hand, we have the risk for the person accused for an infringement of the capital market law. If there is a late disclosure of an infringement of capital market law, this could endanger these persons due to the fact that the number of potential victims and persons who could claim increases the longer the time. Just imagine we have an infringement of an ad hoc disclosure duty. As long as this ad hoc disclosure hasn't happened, many investors could invest or de-invest, and this could accumulate the potential damage, and this is also not in the best interest of the person infringing capital market law, that the whole enforcement process takes a long time, because this increases the exposure of these persons. So there's also an interest of these persons to accelerated proceeding. Therefore, what is the bottom line to that? We do need a highly qualified decision maker who is capable of a swift and accelerated decision making, both personally in terms of knowledge and in terms of resources. And this should tackle with handle the problems that usually there's a risk of asymmetry in resources and capabilities between the market participant and the regulators. And second, there's a typical historical grown bureaucracy or governmental agency that are usually not competitive and fitting to these special market conditions. So Martin already mentioned it, there's a need for specialization. And I mentioned before that I see a conflict of interest between the specialization, acceleration of this decision-making process, and the rule of law or the principle of a fair trial. What I mean? First, we have, of course, because of constitutional and human rights, we are forced in the structuring of these specialized courts to keep in mind that the right to be heard and the right of defense slow down the decision-making process. So this is an impediment to the acceleration. Furthermore, there is also the principle of the prohibition of self-incrimination. So the competent authority have to evidence that there was an infringement. This could lengthen the whole process. Then we have the principle of separation of the prosecution from the judge. So that is an organizational burden. This means that not only specialized courts are competent for the enforcement, but there has also be potentially an official prosecutor. So it's divided, and this could be an organizational burden which tendentially delays the enforcement process. There must be a chain of instances for the review of decisions. Any specialization must therefore run through all the instances. There's not enough just to have a specialized court in first instance. This has to run through the whole chain of appeal. And furthermore, the Constitution in some parts restricts the possibility to involve practitioners from the business community in the decision-making process, because from an Austrian perspective, some cases which are laid with the courts for civil law can only be decided by judges, and not eventually by lay judges, but not from practitioners. these tensions between the acceleration of the enforcement process and on the one hand, and on the other hand, the rule of law will also exist, but the question is how it can be adequately reduced or mitigated. This is the main question. Very important from this perspective is also who are the stakeholder involved when it comes to an infringement of capital market law. The shareholders or the stakeholders could be, on the one hand, individuals, investors, or market participants who try to get damages or performance. Secondly, there's also the economy as a whole, because if the markets do not function properly, this would lead to economic drawback. And finally, the government who wants to safeguard that the rule of law is implemented properly. This results also in a plurality of affected fields of law, meaning we have criminal law involved, so there are criminal law proceedings with reference to the enforcement of capital market law. We have also administrative sanctions, and finally there is also civil law proceeding involved. And these results, as it comes to Austrian law, also in a plurality of competent authorities. For Austria, we have in the criminal law the public prosecutor who is competent for the investigation of capital market infringements like insider dealing, and we have the criminal court on the other hand, who is the deciding body on these issues. Then we have on the administrative law level, on the one hand, the Financial Market Supervisory Authority, and in the upper level, the administrative courts. And for takeover issues, we have the competent authority, Austrian Takeover Commission, with the appealing court of the Supreme Court is the appealing institution, and also the administrative courts could be competent in a certain extent. Both bodies have in common that they exercise not only supervisory but also decision-making and sanctioning functions in the first instance. Only in the appealing process there are courts competent, and in this courts proceeding these bodies, the Financial Market Authority and the Austrian Takeover Commission, are granted party status. So this avoids further fragmentation and makes sure that also these competences are not lost in the appeal process. And finally, we have the civil law issues for the claims of damages or performance. These issues are laid down with the ordinary courts, and the person who starts the proceeding, of course, are the individual plaintiffs. So there are no governmental bodies who bring in claims, so that could be only brought by investors, individual plaintiffs. This is, of course, a danger for uniformity and unity of the enforcement process. If you have different institutions to decide or enforce capital market law, this leads to problem clashes of decision. The one court says there was an infringement, and the other court says the opposite. And how do the Austrian legal system try to mitigate these legal risks in the enforcement of the capital market law. When it comes to the criminal law, we see that the public prosecutor, who is the competent person investigating such crimes, is assisted by the Financial Market Authority and not by the police. Usually the official prosecutor is assisted by the police. But in these cases, the capital market law, there the FMA or the Financial Market Authority is the right hand and assists the public prosecution, so that this knowledge, which is pooled with the Financial Market Authority, is not lost in the process. And further, we have only one competent court. The Criminal Regional Court in Vienna has the sole jurisdiction on these matters. Criminal law offenses are concentrated in this court. So specialization in one court for any criminal law offense. In the administrative law field, where we have, for example, administrative law fines, we see that in Austria all these issues are concentrated in the Financial Market Authority and the Austrian Takeover Commission. These are specialized agency. And these specialized agency, as I mentioned before, combine two functions in one body. One, the investigation function, and on the one hand, and on the other hand, the decision-making body as well. I will come back to this later. And the specialty in these administrative law bodies is that the Austrian Takeover Commission, as Martin mentioned before, allows the participation of practitioners from the business world. So the panel consists of 4 persons, and only one of whom is to be a judge, and this is something special of this enforcement body. When it comes to civil law authorities, we have there is the main question: what happens if the one administrative body like the FMA or the Austrian Takeover Commission decides in a case that there was an infringement of the law? Does the civil law institutions, so the courts, are partly bound by these decisions, or are they not? So the answer to that question is that in Austria, basically, the courts are bound by already made decision of criminal courts, administrative bodies, as the Financial Market Authority or the Austrian Takeover Commission. But if there is no decision in place, they can decide, they have to decide by themselves if there have been an infringement or not. There's only one exception in the Austrian law for takeover cases. The courts are not allowed to decide themselves in takeover issues. In takeover issues, they are required to interrupt proceedings in order to commence declaratory proceedings before the Austrian Takeover Commission, which have erga omnes effect. This is provided for in section 29, paragraph 2 of the Austrian Takeover Act. And there you can see that's an instrument to avoid that many courts in Austria could be competent, depending on who is the plaintiff or depending on who is the defendant, rule differently. There's only one competent authority who have to decide whether there has been a violation of the takeover law or not. And this special feature of the Austrian law lead to very recent decision of the European Court of Justice. It is the decision C546 from 2080, Adler AG. And there the European Court of Justice ruled in a very special, specific case. The substance of the case was that the Takeover Commission issued an administrative decision against the Adler AG, stating that Adler AG had wrongfully failed to make a mandatory offer. In subsequent administrative penalty proceeding, the appeal court initiated preliminary ruling proceedings before the European Court. In particular, the appeal court wanted to know whether the declaratory ruling of the Takeover Commission vis-à-vis Adler AG can also have a binding effect vis-à-vis an affected member of the executive board of the Adler AG, even though this member of the executive board had not participated as a party in the declaratory proceedings. So this was just the case. And the question is, or the question was, is it in line with the human rights that this binding effect could also affect the member of the executive board? And there, the ECG said or ruled that there must be a restriction of these binding effects, and only to those persons who were who had party status in these proceedings can be affected by a decision of the Austrian Takeover Commission. So if this binding effect is has erga omnes effect, it has to be made sure that the party who is addressed by this was also had also the possibility in the administrative procedure to the party status. And furthermore, this decision also questions the permissibility of the combining supervisory board and decision-making authority in one agency, because the European Court of Justice stated with regard to this case that it could not be that it could not be established that there is a functional separation within the Takeover Commission between, on the one hand, the department responsible for investigation and establishing infringements, and on the other hand, the departments responsible for deciding on the existence of an infringement and imposing sanctions. So this combination of two functions, investigation function and the decision function in one body, was seen critical. And the question is, for an Austrian perspective, if on the one hand the Austrian Takeover Commission has to change in the structure to separate this function more intensively, and also for, to my mind, for the Financial Market Authority is also competent for both functions. Even though there is an organizational separation established. However, the ECG ruled if there is no clear separation, the binding effects have to be restricted in other proceedings. And if we look closer to the FMA structure, we have a monocratic body. So the question is if this monocratic structure also fulfills this organizational separation between these two functions. And this is, I think, what is very important for the future structuring of capital market bodies. Thank you very much.
Christoph, thank you so much for your presentation. I think what looks very appealing as a big picture, then when we go down to details, as your talk clearly demonstrated, many things get complex and also need to be addressed. Thank you so much. We will have a discussion afterwards. And now we'll move to the next speaker, my colleague Marcin Mazgaj, who is a graduate of Jagiellonian University in Krakow, now assistant professor at the Institute of Law at Pedagogical University in Krakow. He also graduated from the American Law program by Catholic University of America in Washington, D.C., Columbus School of Law, in cooperation with the Jagiellonian University in Krakow. He was a member of the committee assigned with work to come up with a legislative proposal for a simplified joint stock company for the Ministry of Development. He has conducted research at the Bucerius Law School in Hamburg and was a visiting lecturer at Vytautas Magnus University in Kaunas, Lithuania. And well, together with Marcin, we worked for a long time. Also, the Other Hand Institute has been affiliated researcher at Other Hand for many, many years. He's practicing attorney and partner at the Krakow-based law firm, advising clients on several areas, including corporate, venture capital, and broad business law. And Marcin, we are very happy that you are with us here in Vienna. Personally, your topic will be justice delayed or justice denied, an attempt to determine the optimal limits of jurisdiction for corporate courts, evidence from Poland. Marcin, the floor is yours.
Thank you very much, Arek, for the invitation and for such a warm introduction. It is my honor and my pleasure to be here among such distinguished speakers and guests. I have to admit that previously I've been in Vienna 2 years ago, just before the pandemic, in December 2019, and it's incredible how the world has changed just within those 2 years. Ladies and gentlemen, it is also my honor and my pleasure to share with you some of my views with respect to specialized courts on the grounds of corporate law. My presentation will be based on Polish law, but actually the issues covered by my presentation are similarly regulated also in other legal orders. So I feel that in spite of being based on Polish law, my presentation will have a sort of universal character. Of course, the title of my presentation, Justice Delayed or Justice Denied, is a reference to William Ewart Gladstone's Justice Delayed is Justice Denied. The problem is that in the real world, sometimes we have to choose either justice delayed or justice denied. The paradox is that, as I intend to demonstrate today, sometimes choosing justice denied might not be the worst choice. Before I get to the point, I'll start with a story. As Arek told, I'm also an attorney in Krakow, and a few years ago I was having a phone talk with one of my clients. That client lives in Liechtenstein and conducts his business activity in Liechtenstein. And he just told me that he was establishing a company, a joint stock company there in Liechtenstein. And so when I heard it, I just was naturally interested in what it looks like in Liechtenstein. So I asked him about that, and then he told me that, well, in Liechtenstein we register the companies not in courts like in Poland, but there is a special administrative body that does it. And before the registration, I just went there with the draft of the Articles of Association, showed them the draft, they told it's okay. So then I signed the draft before a notary or somewhere else, I don't know, and I submitted all the documents in order to have the company registered. And then I started to wonder what would happen if I or anybody else would come to a Polish registry court with a draft of Articles of Association and ask them if it's okay from their point of view before it's signed. I see my Polish friends are laughing a little bit right now, because well, the only answer would be, sorry, we do not provide legal service. You can go to the attorney. We will check it when you sign it. And they would answer that way, not because they are bad people. They would answer that way because they got simply lots of work. Their workload is really sometimes extreme in the Polish registry courts. And what I will try to analyze today is how it could be changed, because this problem is not a specifically Polish problem, but it is visible also in other countries. As I told a moment ago, still my presentation is based on Polish law, so in order to introduce the topic, please let me make some preliminary outline. Well, and first of all, in Poland we do not have separate corporate courts, but we do have separate commercial departments in courts in major cities. These commercial departments are established in district courts, which are the lowest instance, or in circuit courts, which are the higher instance. In district courts, we've got registry departments that simply take care only of keeping the national court register, and the litigation departments that simply resolve the disputes between the entrepreneurs. On the other hand, in circuit courts, we have first instance departments, but the litigation only departments, so the departments that resolve the disputes between the entrepreneurs as the first instance, and appellate departments that resolve both litigation cases and occasionally, but rather rarely, registry cases. Apart from district courts and circuit courts, there are two higher instances in Poland, the appellate courts and the Supreme Court, but none of them has specific separate commercial department. There is simply a major civil law department, and the commercial cases are resolved there. Well, so as I said, in the commercial courts, we have litigation departments, but they take care of all the commercial cases, not only the corporate ones, but also they take care of the non-corporate cases, like the ones arising on the grounds of any type of contract between two entrepreneurs. But they also, of course, resolve, in particular, the corporate cases. As regards the registry cases, several important remarks need to be made there. Well, first of all, our business register in Poland, the National Court Register, is a register where records are made only by the registry courts, not by any administrative bodies. Yeah? So the register is kept just only by the registry courts. The second important remark is that well, the role of the register is not purely informative. Well, first of all, many transactions, including many high-value transactions, rely upon entry to the register. Mergers of companies, divisions of companies, transformations of companies are effective upon registration. I think this is not a big difference if we compare it to other legal systems. But even in case of some, let's say, informative records, where the entry is just providing an information but is not creating the new state of legal affairs, like in case of company formation or like in case of the merger, even then the entry still is of some importance. This is due to the fact that in Polish law we've got Article 14 of the Act on National Court Register. If we could just go to the next, next one, and the next one. Yeah, it's due to Article 14 of the Act on National Court Register. I just wanted to show it on one of the further if we could. Okay. Oh yeah, that's it. Well, what does this provision mean under Polish law? Let's give an example. If a dismissed member of a management board enters into a contract by declaring that he is acting on behalf of the company, even though he was already dismissed, but is still entered into the National Court Register, the company will be bound by such a contract if the other party was a third party acting in good faith. So even if the entry is just informative, it still is of some legal relevance. Okay, so here on one hand we see that the entries in the National Court Register are significant. Some high-value transactions rely upon registration, but on the other hand, I would like to show you some statistics. Yeah, that's a data table. The table you see is based on the data published annually, published each year by each registry court. This is the data for 2020. What I did was aggregating this data from all the registry courts, apart from one, for whatever reason the court in Bielsko-Biała did not publish its statistics, but it's one of the smallest registry courts, so I think that the lack of data from that court wouldn't change anything significantly and wouldn't significantly influence the conclusion. But what you see is just a small part of these statistics. This is the part related to the initial registrations of limited liability companies, which, however, are the most popular company form in Poland. So anyway, these cases that are illustrated here are a significant part of registry courts' activities. In the first column, you can see the whole amount of such cases that had, such registry cases, such registrations that had to be made by the registry courts. In the second column, you will find a number indicating how many of those registrations were electronic registrations. In Poland, it is possible to electronically register a limited liability company. It is a very simplified procedure because the articles of association are based on standard articles of association that are set out by the Minister of Justice, and all the documents in such a procedure are standard ones. In the further columns, however, you find firstly the amount of cases that were finished within just one day. In another one, the amount of cases that were finished, that were resolved within 3 days, and in the third one, you will find the number of cases that were resolved in 7 days. If we could go to the next slide, yeah, and once more, when you add the data, this is what happens. 40% of the cases of these particular cases were resolved in less than 72 hours, while 66% of the cases were resolved within 1 week. So if it's so, I think we can say it straightforward. Most of these cases cannot be difficult. Yeah? So on one hand, the registry courts take care of, as I said, high-value transactions of some really difficult cases. But on the other hand, a significant part of those cases usually doesn't require any special legal knowledge, because, as I told you a moment ago, vast majority of those cases are cases based on electronic registration of the company, where all the documents are standard ones. So pretty much the work of a judge with respect to such registration is rather a physical work, like just checking if all the documents are there. But the documents will have a standard content anyway. Okay, so now I would like to show you some other statistics related not to the registrations, but related to the corporate litigation. This is, as opposed to the previous ones, this is not a complete data table. It's just showing the numbers for some jurisdictions, but I included Warsaw, which is the biggest jurisdiction, Katowice, which is like in the middle, and Rzeszów, which is quite small jurisdiction with respect to the corporate disputes. And here you can see the amounts of disputes that were resolved in that jurisdictions throughout the whole year. with respect to mainly limited liability companies. We have the column related to disputes concerning shareholders meeting resolutions, column related to company dissolution, and column related to exclusion of a shareholder. And if you compare these numbers to the numbers that were shown in the previous tables, you can see well, the difference is very significant. If, for example, let's say in Warsaw, in 2020, we had over 19,000 registrations of limited liability companies, while if we consider the cases concerning shareholders meeting resolution, well, these are the cases for declaring the invalidity or for annulment of shareholders meeting resolutions, the amount is much smaller. The amount indicated in brackets is the amount of the cases that were actually finished in the jurisdictions throughout the whole year 2020. So as you can see here, it didn't go so fast as with respect to the registrations. For example, in Warsaw we had 247 cases for annulment or declaration of invalidity of shareholder meetings resolutions, and only 57 of them were actually finished throughout the whole year. Okay, so what's the conclusion arising from all those statistics? Well, first of all, a vast amount of registry cases is resolved quickly, in spite of the significant workload of registry court. And this requires asking the question, is a qualified lawyer really necessary in such cases? Couldn't these cases be transferred out of the court system to some other institutions where not essentially a qualified lawyer would take care of them? Maybe a clerk would be an appropriate person to take care of these cases. On the other hand, we saw that there is a relatively small amount of corporate litigation cases. Actually, the statistics do not cover, of course, all the corporate cases, because, for example, a case involving the knowledge of corporate law may be related, for example, to a contract of sale of shares, yeah? And it was not included in the statistics I shown on the previous slide, but still, well, I think this remark does not influence the major conclusion that the amount of corporate disputes litigated before Polish courts is not a vast amount. This leads to two major problems as regards the current shape of the commercial courts in Poland. Well, firstly, if we consider the corporate litigation, judges who are specialized in company law tend to be involved also in other disputes as well, also in disputes related to, let's say contracts for construction works, in disputes related to sale of goods. So standard civil law disputes. This, on the other hand, leads to lack of full specialization, and it, as Professor Wiener has indicated in the introductory remarks, leads to formalistic approach that are visible for us as Polish lawyers in our practice before Polish commercial courts every day. And secondly, that lack of specialization has a negative impact on the pace of case examination. So, well, that's the first problem. The judges who might sometimes be really well qualified, well specialized, experienced in corporate law, are somehow forced to take care of cases not necessarily involving corporate law. So that's the first problem. The second problem within the area of, well, let's call it bad allocation of human resources, is allocation of cases irrespective of their complexity. If we consider the registry cases, usually even the most complex, most significant registry cases are not resolved by experienced judges, as usually in Polish registry courts the cases are resolved by court clerks, court referendaries, who are still qualified lawyers, but their experience is usually not as extensive as the experience of judges. Okay, so what's the conclusion, and what should be the institutional response to those problems? Well, firstly, in my opinion, there is no need to maintain strict separation between registry departments and litigation departments. In my opinion, also the most experienced judges who take care of, who resolve the corporate disputes should be involved in the most complex registry cases. Secondly, I think that uniform approach to all registry cases is not justified. There is a big difference between a registration of a high-value complex merger of companies and a registration of a simple electronically formed company. These two transactions need various competences and need various experience, but from our point of view, at present, they are treated equally. Yeah? So, in my opinion, two steps should be taken in order to change this. Firstly, some of the registrations should be transferred outside the court system. And here we come to the beginning. That's why I told at the very beginning that sometimes maybe choosing the justice denied option would be better. But of course, I didn't mean closing the court system at all. Of course, it should be still possible to appeal from such decisions to the court. Of course, the courts should still take care of some of the more complex registration cases. Secondly, in my opinion, it would be advisable to establish separate corporate departments within the present structure of courts. Quite often in Poland we hear the ideas that a separate specialized corporate court should be created. I'm not telling that this is a bad idea, but in my opinion, many of the problems that today lead to the conclusion on the necessity to create specialized separate corporate court, many of those reasons might simply disappear if we made those slight institutional changes that were mentioned by me a moment ago. As I told you also a moment ago, transferring some registrations outside the court system doesn't mean closing the court system for such appeals from such decisions at all. Doesn't mean that the justice would be denied. How it could be done is indicated also in the laws of Liechtenstein that I mentioned at the beginning of my presentation. If we could go to the next slide, I think it's number 13. I would just like to show you an example of one of many regulations in the law of Liechtenstein. There also, as I said, a separate administrative body takes care of the registrations. And yeah, if we could go one step further, just in English. But as you can see, even if that administrative body deems it necessary, it may refer the cases simply to a court, to a decision. So it would not be a mechanism that is unknown in Europe. There are some countries, like, as far as I remember, Denmark and probably Netherlands, where the business registers are conducted outside the court system, so it would not be also a revolution from the European point of view. Okay, that's all of my remarks. Thank you very much for your attention. Thank you.
Martin, thank you very much. As we increasingly get to see, specialization is also about the entire ecosystem, how we allocate the work and to whom. Before we turn to the discussion, I was told we will need some 5 minutes break, right? Before we can invite the next speaker here, who unfortunately is not with us physically here, but we'll try to connect online. And I was told, Olga, this is true? We need 5 minutes break, right? So we will need to have just 5 minutes break before we continue with a presentation delivered remotely. In the meantime, I would like to mention and welcome Professor Jacek Jastrzębski, who is the chairman of the KNF, Polish Financial Supervision Authority, who gave a keynote lecture last Friday, but he also came today in presence, joined by Jacek Barszczewski, who is a press speaker of the office. So a very warm welcome, gentlemen.
Thank you, Eric, and I'm really happy to be here among you, among your distinguished guests. I'm sorry for our delay, but we just took the morning flight from Warsaw today, and we are not able to come to Iraq yesterday because of other commitments. So sorry for being late, but happy to be here.
Very glad. So let's use this 5 minutes as you wish, and then we will hopefully we'll be able to listen and then discuss. Okay.
But you know, actually, yeah, but still.
Okay, are we on the air? Can we resume? Okay, after the short technical break, we continue with our first panel, joined with our keyword note, and then we will follow by discussion. But we still have one important speaker, Roy Shapira, who until almost final day wanted to join us on site, and we were very much looking forward to this, but due to these limitations, the travel was not possible, and therefore we will be connecting remotely. Hopefully it will work out. So please let me briefly introduce our next speaker, and then we will connect with Israel. So Roy Shapira is associate professor at the Harry Radzner Law School, Reichman University in Israel. He focuses on reputation, economic regulation, and corporate governance. Roy received his SGD and LLM degrees from Harvard Law School, where both his master and doctoral thesis won Victor Borny Prize for the best paper on corporate governance. During his time at Harvard, Roy taught for 6 years a seminar at the economics department, and at the same time he won 6 Excellence in Teaching Awards and received the Olin and Clark Prize. Before joining Reichman University, Roy was the research director at the Stingler Center at the University of Chicago, and Roy's book, Law and Reputation, was published last year by Cambridge University Press. He also published leading law articles recently in University of Chicago Law Review, Washington University Law Review, Vanderbilt Law Review, and Oxford Journal of Legal Studies. Now, moving to the topic, and I think everybody here is excited because most of the speakers, most of the countries, we just think of specialization, we kind of intellectually test different models, share our experience with some fragmentary specialization. And what Israel has in place already for more than 10 years is this Israel venture to set up a court modeled after Delaware Chancery Division. So therefore, I think this presentation will be specifically of interest because we will have a chance to learn from these experiences, from the successes and maybe some failures. So Roy, I don't know if you can hear us, hopefully so. So the floor is yours, please.
Okay, thanks a lot, Arkadiusz. Can you hear me?
Yes.
Fantastic. Okay, so thanks a lot again to you and to all the others who are involved in putting up this great conference, even with all the difficulties of connecting everyone around the world. I only regret, like you said, that I cannot be with you in person, but perhaps we'll get another chance once the COVID situation becomes less crazy in the future. So let me start right with the bottom line, because we still have to finish the first panel and to get to the discussion. So I want to share with you 3 insights, like Arkadiusz said, from Israel's experience, decades worth of experience with the Specialized Business School. The first insight is more of a background, in a sense that the Israeli Business Code looks to Delaware as a quintessential reference point. In a couple of senses, even before it started operating, the public committee that recommended instituting this Specialized Business Code already cited Delaware as a source for the inspiration. The committee explicitly said something along the lines of, we want to create a court that will have the same institutional features as Delaware's courts of chancery. Then, shortly after the Specialized Business Court started operating in 2010, it became clear that the judges are looking to Delaware also as a source of inspiration for substantive law. So they began changing Israel's substantive corporate law so that it gradually looks more like Delaware's. Okay, so my first argument again is therefore a factual background claim to have in mind, and that is that the Israeli Business Code seemingly aspires to be like Delaware. Right? So what does it tell us? Is that a good thing? Okay, is it a good idea to try to imitate Delaware in a specialized court in other countries? Is it workable? Is it feasible to be like Delaware in other countries? And this is where my second insight comes in. We now have, exactly like Arkadiusz said in the beginning, more than a decade worth of experience with the Specialized Business Court in Israel. And I can use this 10-year retrospective to evaluate whether the attempts to imitate Delaware generated good results for us or not. Okay, and specifically I will distinguish between 2 aspects that we just mentioned. In terms of the institutional features, in terms of creating this specialized tribunal with a small number of judges, 3 judges, who only deal with corporate law issues and securities law issues. And so they develop expertise over time. There's a general agreement, a general consensus that the move to a specialized business court has been a success. In a sense that, like the previous speakers have talked about, specialized court has helped reduce the caseload, processed more effectively, and it also had a big impact on developing the law, on keeping Israel's corporate law dynamic, reacting to changes in market circumstances. However, in terms of borrowing not just Delaware's institutional features, but also its substantive doctrine, here the business court experience is much more debatable, it's open to criticism. Some have criticized the imitation of Delaware's doctrine by saying that Delaware concept, they're simply not so good of a product to imitate, right? So in other words, the criticism is against unquestionably assuming that if Delaware does something in corporate law, it should be the right thing to do, right? On many, Delaware can be wrong, it is wrong on many concepts on corporate law. This is the argument. So why would you import to your country a worse product than the one that you currently have? All right? I will highlight here today a different kind of criticism, namely, regardless of what you think, even if you think very highly of federal corporate, even if you think it's the best corporate law in the world, you shouldn't necessarily want to implant it into your country. And the reason is a very basic premise in corporate law, which is it warns us from borrowing substantive doctrine from one legal system to another without first understanding the context in which these doctrines were developed. And specifically to corporate law, we have to account for the differences in the surrounding environment between Delaware and your country, differences in ownership structures, corporate governance arrangements, civil procedures, doctrine, and so on and so forth. And this brings me to the third and final set of insights that I'll try to highlight here, and that is that based on the Israeli experience with imitating Delaware, we can extract 2 generalizable lessons on what we should look at for the topic of this conference, namely specialized business courts more generally. First, we learned that if you want to evaluate specialized business court, most of the impact of the specialized business court may come not necessarily from its substantive doctrines, but rather from how it applies seemingly procedural doctrines. So from decisions that are made very early in the process, to the screening phase. And the second point is that the specialized business court affects corporate behavior not just directly through its legal decisions, but also indirectly through shaping the norms and the reputations in the business community, so affecting the non-legal forces. So let me now move in the 10 minutes or so that I have left to fill in the details that will be, I think, most interesting for the people in the room today on these 3 insights. First, on the background, so the idea of having a specialized business court in Israel, so do you guys see in the presentation this weird window that I'm seeing right now? Let me try to remove it on what it is. Okay, never mind. Okay, so the idea, again, going back to my point, the idea of having a specialized business court actually came from a corporate law academic. In mid-2000s, Israeli securities regulator appointed, some of you may know, a law professor named Zohar Goshen. So the regulator appointed Zohar Goshen to head a public committee that was supposed to recommend steps to improve Israel corporate governance. And one of the recommendations, this is again 2006, something like that, was instituting a specialized business court, exactly like we were discussing today and last week. So now the committee explicitly said, again, along the lines of, look at how great Delaware has it with their Court of Chancery. Wouldn't it be nice if you could do something like that in Israel? So let's think what they did and did the same. Small number of judges, narrow type of jurisdictions. They develop expertise over time, they develop experience over time. That's enabled them to adjudicate complex business disputes efficiently, enables them to develop a vibrant body of law, and so on and so forth. And then shortly after the business was started operating again, we saw that the 3 judges sitting on it started writing decisions that explicitly turned to Delaware law concept, such as like a tiered standard of review approach, entire fairness, enhanced scrutiny. If you appoint a special independent committee, we will grant you the differential business judgment treatment, and so on. Right? So bottom line, the attraction, so to speak, to Delaware is evident. And now, after we had a 10-year experience, let's see whether the desire to be like Delaware serves us or not. Okay, so again, in terms of the institutional features, I guess the fundamental question that is relevant also to other talks in this conference is how can you measure, how can you evaluate the success of the specialized business school? And I want to offer here several types of indication of the success of Israel move to a specialized court. First, in terms of managing the caseload, we now have evidence that the specialized court initially attracts at the get-go the more complex disputes and handles them relatively more efficiently than other courts, in the sense that it manages to screen cases early. It manages to separate meritorious cases from meritless cases very early in the process, thereby saving litigation costs and reducing the backlog also to other courts, because now the other courts don't have to handle the more complex disputes. Second indication that we can use is that we can see that we have evidence that specialized business court decisions are being read more, they are being downloaded more from the legal databases, and they are being cited more by other courts. So that's an indication that we have that the decision are more impactful than the decision of other non-specialized courts. Further, then relatedly, another way that you can check, kind of a rough check whether specialized business court decisions are making an impact on the law, is to examine the corporate law course syllabus, right, at different universities, to figure out whether law students are studying the decision of the specialized court or they're studying the decisions of other courts. So I did just that. I looked at the course syllabi in corporate law in universities in Israel before the specialized business court in 2009, and then almost a decade later in 2019. And really I saw a stark change. I found that indeed corporate law courses now feature 3 times more the district court cases than they did prior to the opening of the specialized business court. So again, this gives us a rough indication that the specialized court produces precedents that enter the legal canon. It impacts corporate law. A fourth indication of the general satisfaction with the experience of specialized court in Israel came 2 years ago when the Israeli government decided to extend the specialized business court project by opening another economic division with another district court. The original business court was in Tel Aviv. They opened another division of a specialized business court in the north of Israel, in Haifa. Okay, I will add in parentheses here, just for the sake of completeness, that in the past year, Israel also decided to extend the business court so that it will eventually, in the future, will include more judges and deal with more jurisdiction. So kind of taking away some of the narrow specialization aspect. I will not say anything about these future changes because I don't want to predict the future. It remains to be seen whether this change will be effectuated and how it will work, but something to keep in mind if we're having a conference maybe 5 years from now and we go back to speak about it. So back to the point. Overall, there's a general agreement that as far as the judicial output is concerned, the move to a specialized business court has been a relative success. Now we come to the more debatable aspect, because when you evaluate the specialized court, you cannot limit yourself to questions such as, to parameters such as how quick do they decide cases or how many citations do they have, right? The ultimate goal is not to solve disputes quickly. The ultimate goal is to improve your country's corporate governance, right? Like in the title of this conference, to protect investors. Okay, so for that, if you want to evaluate that, you need to evaluate also whether the desire to be like Delaware has led to better or worse substantive law in terms of its likely impact on actual corporate behavior. So you have to delve into the substance of the decision. And here there isn't a consensus, a far from a consensus. There are several criticisms, like I mentioned at the beginning. Perhaps the most notable critique of the specialized court in Israel comes from my colleague Amir Lift. Some of you may know him as well. And Lift argues that eliminating Delaware's concepts such as entire fairness or enhanced scrutiny to regulate related party transactions that are potentially tainted, potentially conflicted, he argues that it's both bad law and bad policy. It's bad law because Israel already has in place a statutory framework and Supreme Court precedents for how to handle these related party transactions. We don't need to go to Delaware for inspiration. It's not like there is a vacuum. There's already a sort of legal framework, legal solution supposed to be binding on this court. And it's bad policy because Delaware's entire fairness concept is the product of an historical accident. And Delaware itself, which claims has been retracting from it recently and going back to the basic principles that were binding in Israel before the specialized courts started looking to Delaware. Again, the point is, why should we import a damaged product? Why should we unquestionably assume that the product in Delaware is dirty? Okay, and I want to highlight here, like I said, a different type of criticism. As I said before, regardless, I'm agnostic, regardless of what you think of Delaware's corporate law, Delaware's substantive doctrines, even if you think that they're good, okay, you might think hard, you might think twice before adapting them to your country. Let me give you two concrete examples as to why. First concrete example is concerns the need to factor differences in market environments. Let's talk about Delaware's framework for approving related party transactions that I just mentioned. So transactions, say, between the company and its controlling shareholder. And their framework is laid out in the MFW, relatively recent MFW decision. Before MFW, related party transactions in Delaware used to be subject to the entire fairness standard almost automatically. So the judges will almost automatically scrutinize the transaction after the fact to check whether the process was fair, whether the price was fair. MFW shifted the approach from relying on ex post judicial intervention to relying on ex ante market mechanism. Okay, so under MFW, as long as the transaction was negotiated from the outset by an independent board committee and it was approved in the shareholder meeting by a majority of the minority vote, the court will grant it the differential business judgment rate, which in Delaware basically means we will reject it automatically. We will not even discuss it. Okay, so for our purposes here in this context, the pertinent part in MFW is the reasoning, right? And the court there explained that the reason that they shift from ex post judicial review to taking a step back and leaning on ex ante market mechanism is because they believe that the market mechanisms have become better over the past decade. They refer specifically to the fact that shares are now being held by large institutional investors. There are all these activist hedge funds. There are powerful proxy advisory firms. So what happened over the past decades, the Delaware courts are telling us, is that these factors combine to make the market for shareholder votes much more confrontational, much better able to deal with controlling shareholder than in the past. So the court is saying basically something like, if these ultra sophisticated players approve a deal in real time, why should us, the judges, interfere after the fact? That's the reasoning to their part. So now, for our purposes, assume that you're a specialized business court in another country, okay? And assume that you think that Delaware corporate law is very good and you need to look for it for inspiration, okay? But before you rush to adopt the MFW framework, you have to ask yourself whether the market for shareholder votes in your country possesses the same qualities like the one that the MFW decision refers to. So do you have in your country constant presence of activist hedge funds targeting and challenging the controlling shareholders? Do you have powerful proxy advisory firms that frequently recommend voting against what the company proposes? So these are empirical questions, okay? Not many securities markets have the same characteristics that the US markets have, right? So perhaps in other markets, such as Israel, institutional investors do not really want to go against the powerful controlling shareholders. Okay, so if you can't answer this question affirmatively, then you have to think twice, you have to think really hard before following the changes in Delaware. Okay, second example, and that's the last example. The second example that I use concerns the need to account also for the differences in civil procedures between legal systems. Delaware's framework for scrutinizing director oversight duties is in the Kermark decision. Okay, so the idea here is that what would be the scope for director's liability for omission, for not doing enough to monitor and to prevent some wrongdoing by company employees. And Kermark sets the bar in these cases in Delaware very high. It says that the court will intervene only if shareholders are able to show bad faith on the part of the directors. So unlike the law in Germany or in the UK or in other places, maybe in Israel also before that, if you show the directors were negligent, that's not enough. Okay? It's not enough that you show the director failed to oversee the company's operation and compliance. Plaintiffs have to show the directors did so knowingly, that they knew they were breaching their duties and they still did it. And so for years, setting the bar so high meant that there was a parade of early dismissals. There was almost no chance to hold directors accountable for failures of oversight under Kermark. And many American legal scholars called Kermark basically a toothless tiger, meaningless doctrine. But over the past couple of years, Delaware has found a way, a new, a better equilibrium, I think, to revive director oversight duties through a seemingly procedural change between shareholder inspection, right? Shareholder rights to information. Shareholders in Delaware and elsewhere in the world usually have a qualified right in the corporate law statute to inspect their company's books and records. And in recent years, Delaware have liberalized the requirements for inspecting the internal documents, for getting internal documents, so they now order provision of documents in more cases and order provision of more types of documents, not just formal board materials, maybe even private emails, private LinkedIn messages, private WhatsApp messages between two directors, as long as it's about the company matter. Okay, so now when you have this very powerful pre-filing discovery tool, investigatory tool for shareholders, so shareholders can more easily investigate potential failures of oversight. They can more easily locate indications of what the board knew, when they do it, why they didn't do enough to start the problem, and so on and so forth. Now, so going back again to our team in this context, going back to the hypothetical. Assume that you're sitting at a specialized business court elsewhere in your country, and you're thinking about what should be the proper framework for director oversight duty. So you should be very careful about adopting Delaware substantive standard, which here is very fair. Okay, without adopting also the concomitant discovery tools that come with it. Here, expensive with an A, pre-filing discovery. But Delaware itself acknowledged that having the Kermark standard without strong discovery tools is not going to work. Okay? Right, so there are additional examples. I don't think I'll get into them today, just for the interest of time. Let me jump right into the generalizable lessons. 2 minutes, and I'm finished with that. The first general lesson, I think, is that when you evaluate the specialized business court, civil procedure matters, and how it applies to procedural decisions matters. It always matters in litigation. It matters in corporate litigation even more. And it matters in corporate litigation, US or Israeli style, with class actions and derivative actions, much, much more. So to illustrate, consider the following number. The last time that they checked, over 5 years, 2011, 2015, the Delaware courts produced 5 final verdicts coming after a full trial in derivative actions and class actions. 5 in 5 years, average 1 per year. Okay? So where does all the famous body of Delaware law comes from? They only have 1 verdict for 1 year. It comes from many, many decisions in the early stages of the process. Okay? Many cases are rejected already in a motion to dismiss. And cases that survive the motion to dismiss usually settle quickly after that, because defendants in the US wish to avoid going through the very expensive discovery and deposition. Okay, so the bottom line for our purposes is that all the standards in Delaware, they basically function de facto as so-called pleading standards, pleading hurdles, meaning that their function is mainly to dictate which cases will proceed to discovery and which will not. Okay, so when you implant these standards into your country, beware, because this is like implanting the engine of one model of a car on the chassis of another model of another. Okay? And so the second lesson is that you can ask yourself, if there's almost no final verdicts in Delaware, how do they guide behavior? How does corporate law guide behavior? So even in the absence of final verdicts reached after full trials, Delaware courts manage, and also Israeli courts, I'll talk about it in a second, manage to guide corporate behavior via non-legal channels, shaping the norms and shaping the reputations in the business community. Because corporate decision makers, they feel the process of litigation in itself, regardless of the legal outcome. Because the process, again, especially in systems where you have expensive discovery, and it's open to the public, like the US and in Israel, the process in itself kind of digs out damning, embarrassing information about your corporate governance, checks and balances, how you behave, and it makes it public for all other market participants to see. So in that way, corporate litigation facilitates reputational discipline of market actors whose behavior falls below market norms. And judges use the opportunities they have to eliminate emotions just such as the request to inspect the company's books or to motion to dismiss, they use this opportunity to voice their opinion on how market actors ought to behave, should behave. So they are promulgating also the norms. And this is where, and I'll finish with that, this is where the institutional features of the specialized court are especially valuable. This is perhaps the most underrated function of a specialized court, at least that I saw in Delaware and in Israel. And that is that all these non-legal effects of affecting the norms in the business community, affecting the reputation of the business community, it hinges on the fact that the business community will respect what the specialized judges have to say, will respect what the judges have to say about what should be the norm and who infringed it. Okay? And when you devise a specialized court of a small number of judges who gain expertise, who have a benchmark, who sit on the same cases, okay, that kind of gives them the respect in the business community. This is the last slide, just a couple of examples. What I did is I looked at media coverage, Israeli business media, and how they cover corporate litigation before and after the specialized court. And I saw that the business media immediately covers all the judges, the specialized judges that sit on the specialized business court, much, much, much more than they covered other judges, even if the other judges in non-specialized courts deal with the same issues. Okay, so they almost become kind of celebrities in the business community. They become well respected in the business community. Whenever you open a newspaper in Israel in a given day, there are good chances that you'll see the picture of one of the two judges that were sitting on the specialized court from the outset. And you see what they say in the decisions, you see what they say in the lectures that they give. And so the business press treats the judges in the specialized court as part of the business community, as relevant to the business community, and they kind of diffuse what they have to say about how market actors should behave and whether a given market actor failed below and acted below the norms, and they diffused it widely, thereby helping the specialized court affecting behavior not just directly with legal sanctions, but also indirectly through non-legal sanctions. All right, I'll finish with that. Thanks a lot.
Roy, thank you so much for this insightful presentation. And well, now it's the time to open a discussion. So everyone on the panel and in the audience might ask questions to any of the speakers. Are there any questions? Ari, please.
Thank you for this great presentation. I have one remark and maybe some question, but the remark concerning this argument, which also appeared last time, that the courts has tendency to make more formal decision, and the reason is that they have expertise in procedural law. I have some experience from Poland. It is not only one reason. I mean, in Poland also there are statistics for judges, and the statistics mean because they determine whether the court is going up in the hierarchy of judges. So more the cases are completed, either way, or on merits or on formal basis, the better the judge is. So this is one reason why they try only reach some formal decision rather than take all responsibility for the merits for the final decision. And well, there are some already many questions, but maybe it's one general question. So it's the question to Professor Wiener. There are so many problems with public justice. There are no commercial courts. So why didn't emerge any private institution, any competition from private institution to fulfill this loophole in the whole system? So it's a very general question, but maybe you will give some hints to this matter. So, okay, I just let voice to other people.
I think we can just right away. I think if you want to.
Okay, thank you. First of all, of course, the fact that the number of cases done counts is a factor which you have to address if you design a court or judicial system. And the way to address it is to properly weigh the workload and not just to look at the number of cases, obviously, but of course, you're completely right. And of course, there are private institutions in competition. That's arbitration. So if parties increasingly see judges as...
It doesn't prevail in practice. That's my problem.
It does not prevail.
Yeah.
It does prevail in practice in Austria with big cases, I would say. So, so it does prevail because even I think that the Austrian system is doing reasonably well, not probably excellent, but reasonably well. But even then, with highly complex and specialized cases, especially where the fact base is very complex, parties tend to go into arbitration amongst other reasons because it is much easier to get judges with specialized factual knowledge on these types of cases. And apart from other reasons for arbitration, especially the lack of publicity, and the faster decisions, which are also important. So I think what you described is happening actually, but probably in any legal system, especially for big cases where it is possible to bear the additional cost burden arbitration carries in comparison with legal proceedings. And that's another reason in Austria why we have arbitration, because with cases with a high volume, arbitration may actually be cheaper than the court system, because the court fees, they are digressively structured, but they go up with the size of the amount. And there may be at some stage a point where arbitration actually turns out to be cheaper, which additionally helps the trend towards arbitration. So that would be my response to your question.
Yeah, I just said because in Poland we have not the same experience. I think that the legal arbitrage is not as much popular. I think that the many cases rather go to the common courts than to the arbitrage. But maybe we are on the way, as in Austria.
It's the bigger cases which go to arbitration, and especially, of course, international cases. One has to say that as well.
If I may have a question to Roy, could you tell us, can you generalize who became the judge in the court? Would it be the same judges who previously worked in other courts, or they were newly recruited from legal community or business community? And can you say something about, as Martin already mentioned before, the new organizational culture? So it is not just who sits there, but also the very philosophy, how you really work. What is your level of user friendliness, right? So because the courts, it is not just the authority, it is also a body that interacts directly with stakeholders. So the keyword user friendly comes up here. So is it something that you can also say that emerged with the establishment of the court? And my last question in the row that I would like to ask you, it was highly interesting that you talked a lot about substantive law, because it seems that the establishment of the court was a trigger for these legal transplants also when it comes to corporate law. Now, this is a trigger, but my question is, what is the mechanics? Because this is not self-evident that establishing a court like this would immediately become a trigger. If I think of, let's say Poland, if we establish a court modeled after Israeli experience, for instance, it wouldn't immediately mean that we would import Israeli concepts. So it is not direct link. So if you could comment a bit on this mechanics of this transmission.
Yeah, quite fantastic question. So first, the who is appointed to the specialized court. They chose judges who were in the district court level, who already had some experience in dealing with civil and criminal aspects of corporate and securities law. And so all the judges thus far came from the bench, already experienced judges. The fact that they were on the specialized court only meant that they stopped doing other cases. They stopped doing contracts, they stopped doing torts, they stopped doing administrative, and now they're doing only corporate law and securities law. And so they already, I think, tried to look for judges that had some experience and expertise in these topics. One judge came from criminal breaches of securities regulation. Another judge came from tax law. Another judge came from corporate law, derivative actions, commercial disputes, class actions. So that's what they did. That's what they have been doing for more than 10 years. That's the only profile of a judge who was sitting in Israeli Specialist Court. Now on the culture, and yes, I think also Arkadiusz, you mentioned in your opening remarks last week, and also Martin today, the point of regulatory capture in a specialized court. I don't think that I can present to you evidence that there are some aspects of regulatory capture, but I think I can sense a tendency, given that they are repeat players and they are all the time confronted with and interact with the defendant side bar and the attorneys of the controlling shareholders in Israel. Yes, I do think that over time they tend to adopt a more favorable stance towards the controlling shareholders. So the culture is still, if you read the court decision, all the rhetoric will be protecting minority shareholders, protecting investors, like the title of this conference and so on and so forth. But the actual decision gravitated along the way towards being more lenient with the controlling shareholders and what they do. Now, in terms of the substantive doctrines and why should a move to a specialized court affect the substantive law, you're absolutely right. I think this is what was so interesting to me. Maybe I didn't explain it properly in the presentation. I think that this is part of your second question, meaning the culture. Because from the setup, the 3 judges that you chose into the specialized court, everybody told them, the public committee, everybody told them, now you'll be like Delaware. Now we'll have a court like Delaware and you'll be expert like the Delaware judges. And every year, there is a conference with Delaware judges and Israeli judges, and they sit together and they talk together with academics about the developments. And I think that there is a point here, kind of also the judges, I think, without getting too much into what they think, there's also a point of judges' reputation. Okay, and the judges think to themselves and believe to themselves that they have to somewhat distinguish themselves from other courts, from judges in other courts. They have to be kind of the experts on corporate law, leading the way, coming with new precedents. And in Israel, in the specific experience of Israel, I don't think that it will happen in other countries. In the specific experience of Israel, Israel is a country where many of our public companies are doing an IPO in the US and are incorporated in Delaware. All the leading law firms are doing their work in English, all right? So there is a very strong inclination towards the US and Delaware in particular. And the Specialized Business Court felt, in terms of kind of the spirit, the organizational culture, we are the little sister of Delaware, okay? And that pushed them away, like Amir Licht is saying, or like I am saying. We think it was the wrong move, but I'm just explaining the dynamics that pushed them towards also looking to Delaware for substantive law solution, even though I don't think that should have been the move.
Thank you. Any more questions, comments?
I have a short question to Professor Wiener, but just with reference to also the question of Ariel Muha. As regards Austrian law, for how long was it obvious that you can, for example, include the arbitrability clause in articles of association? Because maybe that's one of the reasons why why arbitration is, with respect to corporate disputes, more popular in Austria than in Poland. Because in Poland we have just undergone a significant reform in this respect, and earlier it was not obvious whether you can resolve some of the corporate disputes before the arbitration court. Is it obvious in Austria or no?
It's not obvious at all. Okay. First of all, it is impossible for a public limited company. You can't do that. For the private limited company, in theory, it is possible. However, there is an additional issue that the shareholders or the members in a private limited company, from the point of view of Austrian legislation, are typically consumers. So the arbitration, so this touches the question whether arbitration clause with consumers are permissible, and the answer is basically no. Okay. So it can work out if all members or shareholders are enterprises, then you can can include arbitration clauses and hope that the composition of the membership does not change after a later stage, because then it does not work anymore. But as soon as we do have private individuals, we really have serious issues on that one. Okay. And if I just may use the opportunity to very briefly say that was very interesting what you said, because precisely in Austria the registration procedure in the courts is not done by judges in most cases, apart from public limited companies, but with private limited companies it is done by specialized clerks, and I think it works reasonably well. With supervision, by judicial supervision, etc., etc. But in reality, the practice is done by the clerks, and the decisions are taken by the clerks, and that works out. What I wondered is what you were saying. Judges don't want to give advice because they complain of the workload they anyway have and say, I don't have time for that. But you could see it on the other hand that initial advice helps to lower the workload at the end of the day. So from a workload point of view, it might be a good idea to give advice.
I think
just one sentence. The problem with advice from my point of view is rather the issue of regulatory capture again, because if you give advice, you get closer and closer with the community. You may end up in the newspapers being positively described, which as such may be a sign of regulatory capture, by the way, Roy, that the business community says, well, the judges are doing a good job. I would say, careful, that is dangerous. To some extent, I'm exaggerating. So I was wondering whether you couldn't see it that way as well. Thank you.
Yeah, that is actually possible. That one of the issues behind that problem is that you do not have almost any access to the people who are resolving all those cases. In Poland, also the registry cases are usually resolved within the structure of a court and formally, from the formal point of view, by a court, but not necessarily by a judge. Judges, of course, are employed within the registry departments, but mostly these registry cases are resolved also by court clerks who are qualified lawyers, but not the judges from the formal point of view.
Yeah,
sorry, can I just ask hello, thank you for your presentation, Professor Shapira. Just a question for Professor Shapira on the exact jurisdiction of this specialized court. It decides on what kind of cases, only of publicly traded companies or also non-publicly traded companies?
Also private companies. I think this goes to the second part in Arkadi's question before that I haven't answered in full. The reason that the court attracts to begin with certain cases, I mean, if you're a plaintiff, if you're a defendant in Israel, the litigants can choose. They can choose between the specialized business court in Tel Aviv and another court which is not specialized, submit your corporate law dispute in another dispute court, right? And the reason that the most complex cases almost, I won't say always, but dominantly go to the specialized court in Tel Aviv is that the litigants feel like they have more certainty, they have more clarity. They don't need to explain a certain very complex business concept to judges who may be dealing with them for the first time. So the litigants themselves opt into the specialized court, the complex cases opt into the specialized court in Tel Aviv, and they like the judges there because the judges there speak their language and they can understand quickly what is going on. And to your question, so it wouldn't matter if it's a public dispute or if it's a public company dispute or a private company dispute. My guess is that the main criteria would be whether the lawyer thinks it's a complex business case and he wants to have a judge that has that expertise, or whether the lawyer thinks that it's a very simple contract law principle case, and then he can go to whatever district court she chooses.
May I have some maybe follow-up questions? Because this is highly interesting that you have the choice, but this is the choice that the plaintiff makes each time the plaintiff goes for litigation, files a suit. Because if it is so, if you have every time kind of competing jurisdiction, this is in a way, I must say, surprising. I can say when we were working on the proposal for the capital market court in Poland, the idea was it would be mandatory, it would embrace listed companies, and any other company could have a chance to opt in. But once you opt in, this is your court. And it would not be decided every time somebody files a suit. Now, if you have this choice, then I could think of, you still have some room for judicial arbitrage. Like, think if you have an action to invalidate a resolution of the shareholders' meeting, where it would have an erga omnes effect. You have many people possibly affected and many people who could be a possible plaintiff. Now, a plaintiff that is close to the dominant shareholder would go to the court which is more friendly to the company, specifically to have a pending case so that it will stuck with a court that is more likely to be favorable to the dominant shareholder. So just using this shopping technique. Is this risk materializing in Israel in a way?
Yes, so there's definitely, there's always been elements of this forum shopping in the Israel system. And speaking specifically to the specialized court, I think that this is not that much of a problem. When I say problem, I mean in the way that you describe it. Because say that, like we discussed before, Professor Wiener, the risk of regulatory capture. So if I understand you correctly, you're saying this kind of balances the risk. Because if the specialized court leans one way, leans toward controlling shareholders, then the minority shareholders will start submitting their disputes in other courts. But I think that the reason that this dynamic doesn't transpire is that what we see, remember that I have one bullet point in the presentation where I say that the decision of the specialized business court are being relied on heavily, much more heavily, by other non-specialized judges. The non-specialized judges think to themselves, okay, this judge, she has been sitting on exactly this type of disputes for the last 10 years. For me, it's the first time that I'm sitting on this dispute. I'm going to see what she did in her case, and then I'm going to copy it here. Mm-hmm. And so the plaintiff lawyers, the lawyers that represent the minority shareholders, they prefer, like I said before, they prefer submitting to begin with to the specialized court, because now they know that the procedure will be much better for them. And instead of going for a non-specialized court, where they have much more uncertainty, and then they end up with the substantive law, that the judge would just say, okay, I'm going to copy what the specialized court did. Okay, so this kind of mitigates the dynamics that you anticipate. Mm-hmm.
Do we have any more questions or comments?
Just back to this conversation between Professor and Marcin. I mean, one experience from Poland about the contact between judges and clients of the court, so the parties. I mean, my wife is a judge and she's partly on the civil department and partly on real property register. She's constantly complaining that she cannot, it's prohibited to contact directly parties via, for example, phone call. She must ask her secretary to make a phone call, and it sometimes goes to the problem because there must be like 3-time exchange of application because secretary can't explain everything what is needed in the application. So not only overload of job, but some problem with understanding of impartiality and independence of the judges. We are very strict in Poland to the extent that the judge is sitting in his room and there is no availability to come inside and have a conversation with a judge. That's also a huge problem which leads to the time consuming and an extensive process pending of the suit.
Very briefly, of course, I mean, the word nobody's mentioning in the room is the big C, that is corruption, which is, of course, an issue. I've seen that in another state, in Albania, for instance, where the entire commercial register was designed around the principle that the judge or the registrar should not have any contact with the parties under no circumstances, because that was the most important thing. I understand that, but I always want to warn that the main function of a business register is not to avoid corruption. The main function of the business register is to get reliable and fast entries. And a condition is no or as little corruption as possible. But it always depends on how you weigh those different factors. That probably depends also on the experience you have had in different jurisdictions. Our experience in Austria is, of course, we had corruption, especially in the business register, where the corruption typically was like, look, I don't have any more, I'm overworked, I don't have any more man hours, but if you pay my overtime, I will do your case fast. This used to happen back in the dark ages, which are not that long ago, but considerable time. I have no experience the way this is today, but probably Christoph, who's got great practical experience, can comment on the way the commercial courts work with the register, how easy it is to influence the judges. But of course, regulatory capture happens more easily in such circumstances. There's no doubt about it.
Yeah. Question and just a comment for Professor Majgai. Did you think about establishing a business register agency? Because we did it in Serbia, so transferred the competencies from the commercial course to the specialized agency. Of course, we provided for the judicial review, and it was a very good solution.
Yes, that's exactly the solution I'm suggesting, but not with respect to all the registrations. I think there should be one register, but both the agency and the court should have access to that register and should be able to make entries in the register. But yes, generally that's the right direction, in my opinion.
Just one word to the commercial register in Austria. There's no corruption at all, but there is a lot of forum shopping because you already know the practices of the judges, the competent judges, and if you also know that you have a tough one, there are some mitigation strategy. One is to change the company name, because then another judge will be competent. And the second one is to switch the court district by shifting the corporate seat to another political district where you could also avoid the judge without changing your company name. That's practice in Austria, but no corruption at all. No way.
If I may add something, I think it's exactly the same in Poland right now, I can say as a practitioner. With one exception, I think changing the name wouldn't work in Poland, because the cases are assigned in some different way than that. But there's no corruption at all, to just a big workload, but that's all.
Since we are already lagging behind the time, if there are no immediate questions, I would like to thank our speakers, panelists, who are here and who are joining us remotely. Roy, thank you so much for joining us. It's a pity you couldn't. I know you wanted to visit us, but I hope there will be opportunities in the future. Thank you so much for presenting. Thank you for your questions and discussion. Now, let's have a coffee break. And see you after the break. So, Olga, how much time do you have? 15 minutes? So 15 minutes coffee break.
For our second leg of today, which I have the honor to moderate. And I'll just start by briefly presenting our two speakers, and then afterwards we will have the two presentations and then have a joint discussion at the end. First of all, we will hear Andrea Sorsi. Andrea is an associate professor of business law at the University of Florence, Italy, obviously, and also attorney at law. And you're specializing in company and insolvency law, basically. Andrea studied at the University of Bologna as a doctorate from Brescia and a postgraduate degree from the NYU School of Law. You've been a member of various national and European research groups, especially regarding various aspects of insolvency. And one of your current topics, if I understand it correctly, is the minority elected directors in listed companies, a very interesting topic, which is also here in this country of some interest. But you nicely say that your interest in litigation and court efficiency is not just as an academic, but as a citizen, from a citizen's point of view, a view all of us, of course, have as well. And Andrea will talk to us about, the Italian experience of company and investment litigation. And then afterwards, we will turn to Ivan Romashenko. Ivan is an associate professor at the Department of Civil Law, Taras Shevchenko National University of Kyiv, where you also graduated before going abroad into Leiden, where you got your master's and also your PhD, the PhD on related party transactions and corporate groups, which was not co-authored, but co-chaired or co-supervised by Arek Radwan here, apart from Professor Bartman from the Netherlands. Anyway, your current project, or one of your current projects, is also very topical, namely digitalization in company law. And you will be talking to us about the judicial specialization and protection of minority shareholders in Ukraine, and you will compare that with various other jurisdictions, Germany, Poland, and the Netherlands. Now that's it, so I'd ask you to use up 50 minutes each, please. Andrea, the floor is yours.
Thank you. So, just okay. So this controls the slides. Does it successfully? So thank you very much, first of all, for the invitation to Arkadiusz. It was really a pleasure, and I just complimented him personally on insisting on having an in-presence meeting, which is more than more needed in these times. So, due to, let's say, to time constraints, I will skip the initial self-flogging that usually Italians do, saying that how terrible our courts are. But actually, they're terrible, but not so terrible. Can we skip directly to slide 11? I do it directly, yes. Oh, yes. So these are a little bit of statistics that say things that we already know, that trials are slow, that it takes ages to get to a decision. And so the problem is, how can we cope? Because after all, we are a fairly civilized country, and we do have business litigation. And so how can we deal with this business litigation? So are you... Okay, so I just wanted to skip directly all these slides on statistics. I just wanted to concentrate. So I have a long introduction on the context of business litigation, because I propose sort of a taxonomy just to understand what we intend for business litigation. So first thing is that we have, let's say, general business litigation, except for company law, so business contracts of any kind, distribution, supply, non-equity joint venture, debt financing, you name it, insurance contract, all go to ordinary courts. It's 140 approximately. It sounds silly to write approximately, but it's basically some are closing down, some are, let's say, just divisions. So the figure is approximately about one per province tribunal, and they are decided by a single judge, not a panel in first instance. So even if the case is enormous, complex, there is no way for the single judge to ask for a panel to decide it. So that's what happened with standard litigation, which includes also all kind of business litigation, which is not IP or company law. So since about 10 years, it is compulsory to mediate, so to say, to look for a, let's say, amicable solution to in some matters. Some are non-business matters, which I am excluding, sort of wills and estates. But as far as we are concerned, any kind of litigation in banking, investment, insurance, and business leases, also normal leases, but we are in business, we're discussing business cases, have to be, one must seek at least to try to mediate and settle before court. Sometimes it's just a very formal proceedings. The party is, the defendant says no, and that finishes it. Sometimes you actually go into the matter. Sorry. However, this need to, let's say, try a mediation is also satisfied as regards banking and investment by going to these arbitrators that are not really arbitrators. They're called arbitrators, but they're just predictive justice. They're a panel. They're panels. They started with the banking one, so it's created. It's basically sponsored by the Bank of Italy and mainly organized by the Bank of Italy. That has a great prestige in let's say in Italy. It's one of the few institutions that still has, so it's a panel, and there are 7 territorial panels now and 1 coordination panel, so to say. It was established in 2000. Oh, wait, does it go forward? I wanted to go back. Sorry, just. And it basically tells the parties what the likely outcome of the case would be. It can only be used by non-professional investors, so not necessarily consumers, but basically not. So it also includes enterprises that are not within the category of professional investors defined by the law. Counsel is not compulsory, but is usually used. There is no loser pay rules, because that's another staple of Italian litigation, is that who loses the case pays also the other party's expenses. And his decisions are not enforceable, in the sense that the only, I would like to go back, the only, let's say, sanction for non-compliance is a public shaming of the bank. So basically, if there is a publication of the non-compliance, a notice of non-compliance, and usually banks comply, except for already litigated matters. So there are basically 90% of non-compliance notices regard 3 issues that are heavily litigated in court, and so basically banks are not complying, waiting for the courts to decide. Then if the decisions are negative, they will comply. If not, they will not. It was a limit of 100,000 until recently. Now it's 200,000, but still it's a small limit in banking. So basically, to this banking authority, it intercepts claims that would probably not be litigated at all, or would be litigated only at the upper level. But it's important because it was the model for another arbitration panel that is not an arbitration panel, because it's had a structure that is identical to that of the ABF, this ACF. Its institution at the Securities and Exchange Commission, the CONSOB, the Italian. It only has 1 panel, and it has started operating in 2017, but adjudicates claims of up to 500,000 euro, which is not a small claim in Italy for investments. Just to compare the investment, so even before that there was the depositors guarantee scheme compulsory by directive that for deposits that was up to 200,000 euro. In Italy, basically, protection of deposit was unlimited. It was up to 1 million officially, then they had to lower it, but now it's, instead for investments, it's now 20,000. That's still the minimum threshold. So it's, as just to give you a dimension. Now, so 500,000 of investment is not really a small claim. And many things that are decided by the ACF would have gone to court and did go to court before it was started. Also this, we have the same mechanism. They're not compulsory. Non-compliance is just shamed upon. Of course, if it would be an excellent basis to start an ordinary case. If you have a decision that's favorable to the investor by the ACF, the intermediary, the investment fund, does not comply, you go to court unless there are very, very different facts that come out in the evidence phase. Is most probable that they will decide accordingly. It's interesting because these arbitration panels that are not such both follow the courts. So when there are established precedents, they often invoke them. But also, since they're much quicker than courts, they make case law. So when a new issue comes out, surfaces, the decisions of these two arbitration panels, so to say, arrive much earlier than courts, and are usually very deeply grounded. They are discussed very well. One of the factors, I must say, was to select people of great prestige in the panels. So they are good decisions, reasonable decisions made by prestigious people with a good standing. It was so successful that now they're starting it for insurance claims. It's still not operational, but we'll see what will happen. So yes, excuse me. I'll go back to insolvency law later, but now just a matter on IP and company law. So what happened here? So I think you had a presentation 2 years ago by Paolo Mondini here that I talked to him before. I won't want to repeat his presentation, but we discussed the matter. So just to make it short, what happened, I think it's an interesting example, is that in 2003, intellectual property courts were created. It's not actually courts, but it's divisions of court. We have constitutional constraints to create special tribunals. And it was 10 intellectual property courts. Then in 2012, the jurisdiction of this court were also extended to company law, not only to IP law. The number of courts was increased from 10 to 21. Basically, it's every region has one, Lombardy has two, and Sicily has two, just for I suppose historical reasons or for dealing with the cases. There are probably too many, but that's better than nothing. So then you have 21 courts that decide company law cases, and they are quite broadly defined. So company law and related matters. So it's not too narrow. So it's also contracts that involve the sale of shares, for example, or shareholders agreement, investment contract that include equity investment. Then you have special rules for antitrust cases, but we can, let's say that those are very super niche. So this is the picture. What this has then, let's say, and so I'll go back to it later. Just before discussing the effect of company law specialized courts, a note on arbitration. So pros and cons are very well known, kind of especially in general. In the Italian context, we have the issue of cost that is really very high. Decisions are basically unappealable, which is good or bad depending on who you get as an arbitrator, basically. You have an issue in selection of arbitrators. Awards are not published. And also, very specific to the Italian context, basically most of civil litigation based on contract is avoided, or let's say is dealt with immediate payment orders by judge. So if you have an arbitration clause in your contract, this rules out the possibility to obtain payment order. And so that's something that you should think about when making any kind of contract. Also, arbitrators cannot give precautionary measures. That's a big limit. In company law especially, you have some problems in defining what exactly can be arbitrated and what cannot. For example, if you sue against a balance sheet, some people say no, balance sheet, if it's a forged balance sheet, that's a nullity and that can't go to arbitrators. It will be solved most likely. But especially you can't obtain interim measures apart from suspension of resolutions, of shareholder resolution, which is very important because basically Italian company litigation is based on that, as we will immediately see. I took the Milan experience. This is the Chamber of Commerce of Milan Arbitration Chamber, and you see the cases litigated are increasing, but it's still 60 a year. That's kind of nothing. They may be important, but just to compare to the tribunal, it's just the Tribunal of Milan out of, it's a very important tribunal, but it's still about 1/5 of national cases. You have 760 cases litigated in company law every year. This is 2018. This is the value of arbitrated cases is quite high. It was higher than it was. 4 million in 2020, it was 2 million in 2019. That's probably the 2 million figure is more significant. Anyway, it's really a niche in the niche, the arbitration for company law, and you have various aspects. So that make it problematic. I don't really think it's a possible choice for all companies. I wouldn't suggest it, at least in many cases. So. What I wrote in 2016, I wrote a paper, it was published in 2017, discussing the European Nevada hypothesis. So I basically said that Italy has such a terrible judiciary that why not come to Italy to incorporate if you want to protect managers and controlling shareholders, because basically minority shareholders will take so long and so to obtain justice that and would find incompetent courts that make it fuzzy. There's the loser pay rules. Basically, come to Italy and you'll be, if you're a dominant shareholder, you'll be okay. Because of course this is based on the idea of regulatory competition. We know that it's very difficult for states to make investments to decide to attract companies. But if you don't have to make investments, well, just capitalize on your inefficiency. However, this proved wrong, I must say. From 2016 to now, things have significantly changed. We have 10 years by now, almost 10 years of experience of company law specialized courts, and it has completely changed the scenario, the quality of judgment, the rapidity of judgment, the timeliness of judgment. So we have had a great performance of the Milan court, but especially an extraordinary influence on the other courts. The Tribunal of Milan decided to publish all its decisions in a very accessible manner. There was a project sponsored by this non-profit association in which all decisions, all of them, not selectively like in law reviews usually, and this caused really a noticeable improvement of the quality of judgment. It's important because now judges of also peripheral courts can rely also on the specific setting of facts that is set out in front of the Tribunal of Milan and of course of their tribunal. So it's much easier to make analogies and decide cases more consistently. So if you look at the time to clear the docket, the times are still very long, but actually I'm not sure that this really is so terrible. There are some, let's say, some loopholes nonetheless. can I have 5 more minutes? I divided the litigation into, let's say, some macro categories, let's say, just to characterize the Italian litigation. So we have director liability, in which you have, let's say, 3 kinds. You have company or derivative lawsuits against the directors, lawsuits by the creditors, or and then lawsuits by single shareholders aggrieved by the director's behavior. So the first 2 are very common only when bankruptcy proceedings are opened. In this case, it's the trustee that sues the directors. And this, I wrote, is the Chianti of Italian litigation. It's just something, a standard thing that it always works. You sue them, it takes some time, you obtain judgments, sophisticated judgments. You usually settle with most of them, but it's kind of consistent value over time. It's a good investment to do this kind of lawsuits. Then you have director liability in LLCs. Only in LLCs, in limited liability companies, the GmbH, let's say, the equivalent, you can obtain not only damages, but you can obtain interim removal of directors. What you cannot do in with the let's say with the joint stock company. In that you can only sue derivatively for damages, and this also proved quite quick. Judges decide in a matter of, let's say, not days, but months, short months. It's complex cases. And once you remove the director, basically you don't really even have to look for damages. You satisfied your need for justice in most cases. For all companies, but that's particularly important for the joint stock companies, you also can have a company inspection. That is something that is also quite quick, is not considered doctrinally litigation properly. It's something similar to that thing, the procedure that Bastian Kemp talked about in the Netherlands, I suppose. You inspect the company and you can obtain the removal of directors. It's called the 2409 in jargon. Shall we do a 2409? Yes, let's do a 2409. That's what you do. So that's also works quite well, and it takes not so much time. Then challenging shareholder resolutions is the other kind of intra-corporate disputes. And basically also here, either you get a suspension or there's no really point of continuing. So either imagine you have to block a merger or you have to block the election of directors. There's no point in nullifying the election of directors after 2 years or after a year and a half that they're there. You want to get rid of them right away now. So basically, interim measures are quite common, and also these are quick. What remains in the background is damages. Damages is an issue. I'll go back to that in a moment. Then you have purchase agreements. Why doesn't it go on? Next slide. Okay, but investment contract. This is like standard litigation. Shareholder agreements also. You do notice sometimes a difficulty in assessing damages when you litigate this kind of matter. Also in intra-corporate disputes. So basically, summing up the litigation, just very quickly, if interim relief, injunctive relief is key, then finished. Let's say the system works. If you're talking about actual damages, it takes some time, but it works. If damages are somewhat punitive or require really, really sophisticated assessments, then we do have probably a lack of, let's say, it can get better. However, I think there are some perspective. In IP cases, for example, damages are now commonly awarded in a very sophisticated matter. There was a rule, especially on disgorgement of profit, that enabled the doctrinally to elaborate on the point, and courts are no longer shy in assessing damages. And also you have this instrument of aggravated procedural liabilities, basically some form of contempt if you insist on a behavior that is start being used, for example, for companies that repeat egregious behavior. So I think this makes litigation feasible. And all of this, and now I'll finish here. I'll leave it to my paper on the proposal for insolvency law. Suggests that the experiment really worked, and it's an experiment that's kind of a low-cost experiment, because it's just divisions in ordinary tribunals made of ordinary judges that just started to discuss only that kind of cases, and this has had a great, let's say, ripple effect on the company law litigation. Thank you.
Thank you, Andrea, for this overview. Also for the end, the Duke Specialized Courts or Specialized Divisions. Now we'll turn immediately to our presentation on the Ukrainian experience. Ivan, please, the floor is yours.
Thank you. Thank you very much. And first of all, I would like to thank you, the Polish Academy of Sciences, and Professor Arkadiusz Radwan for giving me the opportunity to present my presentation today and to come to Vienna during these COVID times. It's a real pleasure and honor for me to be today with you in this really honorable society. And in my presentation, I would like to cover the topic of my presentation is about judicial specialization and protection of minority shareholders in Ukraine and in selected Western jurisdictions, namely in the Netherlands, in Germany, and in Poland. And I would like to divide my presentation into three stages. First of all, I'll talk about the existing system of courts in Ukraine. Then we'll refer to the experience of court specialization and protection of minority shareholders in selected jurisdictions, and some conclusions and further perspectives of regulation. So I first of all would like to say that in Ukraine we for quite a while are in a process of reform, judicial reform, and in 2016 there were important decisions adopted in Ukraine, among others two laws: a law of Ukraine on changes in the constitution of Ukraine and law on the court system and status of judges. Those laws changed the whole court system, namely instead of a four-level system we now have three-level system. Before we had local courts, appellate courts, specialized courts, and Supreme Court of Ukraine. Now we have specialized courts, but they are not a level stage between Supreme Courts and appellate courts, but rather they exist quite separately. Those two specialized courts today in Ukraine are higher court on intellectual property and higher anti-corruption court. And as for the higher anti-corruption court, I will talk a bit, but it was truly introduced this court under pressure of international donors, international partners of Ukraine. It's a very touchy topic for Ukraine. And there were also other reforms introduced, like formation of the High Council of Justice and changes in the appointment of judges, salary of judges, advocates' monopoly to represent clients' interests in courts, and constitutional complaint. In 2017, we saw the next stage of reform, namely brand new procedural codes were adopted, the new economic procedural code, the new civil procedural code, the new code of administrative proceedings, and the new economic procedural code laid down the basis for the activity of the higher court for intellectual property. In 2018, more changes followed, namely the changes that were concerning the higher anti-corruption court, the law of Ukraine on higher anti-corruption court, and the law of Ukraine creation of higher anti-corruption court. I have to say that I will not stop on detail on higher anti-corruption court because it's a public law and it deals with criminal proceedings, which is not very much related to our topic today, but I have to say that it acts both as a first instance court and an appellate court, because there is a separate chamber for certain criminal cases that come to this court from local courts. It exists since 2019, and it already has a separate website. So this is how today the court system of Ukraine looks. We have local courts, appellate courts, and Supreme Court. Local courts are general courts, economic courts, and administrative courts. The same division goes for appellate courts, and in the Supreme Court we have 4 cassation courts: civil, criminal, economic, and administrative sections. And there is the Grand Chamber of the Supreme Court. Besides these general courts of general jurisdiction, we have Constitutional Court, and as I already said, 2 specialized courts: Higher Court for Intellectual Property and Higher Anti-Corruption Court. As for the Higher Court of Intellectual Property, unfortunately, it has not been yet functioning, although the basis for the functioning was laid back in 2016 and 17. The legal entity of the court is already established, and there are some legal provisions in the economic code. Elections of judges are ongoing. There is no website so far, and it will deal, after it is established and starts functioning, with intellectual property disputes like copyright, patents, neighboring rights, and some disputes with the Anti-Monopoly Committee of Ukraine. So this is how the court system of Ukraine looks like. And as for the corporate disputes, economic courts deal with corporate disputes. So I showed it on my previous slide that there is a separate pattern for economic courts. Cassation economic court is the section of the Supreme Court which deals with corporate disputes. There is a separate chamber in the cassation economic court of the Supreme Court. Unfortunately, corporate disputes are not arbitrated in Ukraine, although I have to say that there is quite a reputable institution in Kiev, which is International Commercial Arbitration Court. I think it couldn't be a forum for such disputes, but of course the judges there are not specialized in corporate disputes. It would take time for them to, or maybe there should be another procedure to, as today Professor Wiener outlined the intricacies of the judges' specializations. There may be other issues with judges' specialization in this court if we have arbitration for corporate disputes, and we don't have a specialized court as there is one in Delaware or in the Netherlands. So talking about minority protection in Ukraine, and the main question is, do minority shareholders have standing? Yes. When we talk about corporate disputes, which is disputes between shareholders or disputes with the company and about their corporate rights, yes, for derivative actions, shareholders that have 10 or more % of share capital can sue an official of the company, for damages on behalf of the company, but for other disputes on behalf of the company, no. And this is a practice of the well-established practice of the Supreme Court, because the Supreme Court, although it meets a lot of disagreement among lawyers and attorneys, they say, why don't minority shareholders sue a certain file an action about invalidation of a transaction which does not meet the law requirements, but the judges are quite firm in this respect. They say that it is the function of the company, and shareholders do not represent the company. It's not corporate rights. So here they cannot sue, but there is an exception in the law of Ukraine on joint stock companies. Shareholders can file a claim about invalidation of related party transaction if it's not on market terms. It's an exception. And also we have a special procedure which is not very institutionalized, but there are rights of shareholders in private companies and in public companies to appoint a special auditor, court is not involved in this process. The shareholders rather have to make a contract with the auditor, and the company has to provide documents to this person. And the law, I would say, the regulation is quite modest because we don't have any consequences of the report of an auditor. And here I would like to go through to my second topic of my presentation about specialization and court and protection of minority shareholders in separate jurisdictions. First of all, and I would like to mention the Netherlands, and I will probably be brief here because there were already very nice and interesting, deep presentations about the enterprise court of the Amsterdam Court of Appeal. Of course, not to repeat my colleagues, I would just like to say that there is standing for shareholders to file petitions for inquiry proceedings, and before the petition is filed, the company has to be informed about the management and supervisory boards about such a petition. And if the petition is accepted, then the court shows that there is some doubt about the appropriateness of the corporate policy in a company. And then there is a two-phase proceedings. The first phase is the establishment of mismanagement, wanbeleid, in the Netherlands. If it is established, then there are other remedies that can be taken by the court. As for the Germany, no specialized court as we know it in the Netherlands, but the court system consists of ordinary courts and specialized courts, including labor courts, administrative courts, fiscal courts, social courts, and there is a special federal patent court. And in German public companies, there is a derivative action which is this right is vested with shareholders that have 1% of share capital or 100,000 euros of their shares. And in case there are also provisions for German public companies in the Aktiengesetz that shareholders have the right to request the court to appoint a special auditor. As if we compare it with the Ukrainian regulation, for example, we don't have the court involving in this process, but here it's the other way around. Shareholders request the court to appoint an expert, and if this auditor finds that the company suffered damage, then the court will appoint a special representative to represent the company's interests in court. In Poland, there were quite deep and substantive presentations about regulation in Poland. My overview here is probably more superficial. So there are no specialized courts, but there is a lot discussion about capital market court. In Ukraine, we don't have such a wide discussion about the need for a separate specialized court. And the court system consists of common courts, administrative court, military courts, and economic corporate disputes are dealt with by common courts. Derivative action is in place in both private and public companies, and in listed public companies, there is a right to request a special auditor for shareholders, which have at least 5% of company in a share capital. And if the meeting of shareholders does not appoint an auditor, then shareholders who initiated the request may apply to the registrar court. What especially is for me is
attractive in the Polish regulation is that there are consequences of how this report is considered. This auditor report has to be presented to the management and supervisory board and should be publicly disclosed. So as for the future perspectives of court specialization and protection of minority shareholders, yes, there is quite a strong view that they should be arbitrated, as in in many other European jurisdictions. However, I guess the main reason why they are not arbitrated still is the fear that there can be some abuse by arbitrators in the proceedings. So, if answering the question whether a specialized court is needed in Ukraine, I would say that it could be if it is created. But if there is a political decision to create it, then a lot of other efforts have to be taken, and long-term efforts, including changes to the statute, time, location, judges, specialization, resources, and infrastructure. And from the experience of the Higher Court for Intellectual Property, which the decision about it was in 2016, we still don't have it. Already 5 years ago, it was the law of Ukraine, and then it was on paper. So I believe that it would take at least 5 years, if it is, or even more, to have such a court in our reality. But I would say that maybe so far it would be preferable to focus on some short-term changes, namely to focus on the procedure about the involvement of special auditor and to improve it, as I guess, and to substantiate it more, as we see it in Germany and in Poland, where the auditor's report is considered by the company, and there are consequences directly in the law for the consideration of such a report. So I guess from the short-term perspective it would be more preferable, but from the long-term perspective I think that it would be also a good solution to have such a court, of course, as we see. So this concludes my presentations. Thank you for your attention.
Thank you, Ivan, for this very interesting presentation, also for your time discipline, which was just great. I think we have some 15 minutes for questions. Arek, is that right?
I think yes, 15 minutes.
Okay, so then I would kindly invite you to pose your questions, if there are any. So, Arek, please.
Yes, I have two or three questions. Yeah, thank you so much. I enjoyed a lot of the presentations. So you see who is the real boss here. So this is the boss. This is the deputy boss. That's how it works. Yes. So again, thank you so much for the highly interesting presentations. I have two or three questions. Question number one to you, Andrea. Did the improvements, because this was my understanding, my takeaway from your presentation, that over the last time, but contrary to your earlier paper, the improvements have been implemented in Italy. Did it somehow affect negatively arbitration, because arbitration has more room if the judiciary underperforms? So is there any relationship visible that the state courts would take more of the pie when it comes to litigation at the expense of arbitration? And also a question that has to do somehow with authority. You referred to Tribunale di Milano, right? Even if it is not officially so, does this tribunal have some leading role as authority, or is it just the same as any other court in Italy? So this would be my question to Andrea, and a question to Ivan. You briefly described the entire landscape and gave us 2 examples of specialized courts already in place. And you were just quite quick with jumping over arbitration, anti-corruption court, because it does not have to do directly with corporate disputes. But still, I think there could be some link, because corruption could be in different spheres of public authority, and the courts could be one of them. And this could basically improve the functioning of judiciary, not by solving corporate disputes, but by fixing problems with the judiciary as such. And my question would be if any improvements in the general landscape of the judiciary have been discovered or created through this, how much of the corruption cases actually had to do with judiciary, which is one of the branches of the government. On this note, I had one story from Austria here. I spoke some time ago with the ambassador of Albania, and he told me an interesting story about Albanian efforts to limit corruption specifically into the judiciary. And the way it did so was not so much through the special court. Instead, they implemented some substantive laws concerning transparency and disclosure of assets of the judges and how they earn those money. And as a consequence, almost all of the judges of the higher courts had to go. And then for quite some time, they had only vacancies. There was no political agreement to fill in those posts. And through this, I don't know, side effect or not, through this legislation, suddenly the posts were not occupied because almost everybody had to go. So just this question, whether it somehow remedied the situation as such in the judiciary.
Okay, so this is the working mic.
Okay, first question, that's an interesting question. I would say I don't have a date about that. I think that arbitration, all in all, is growing nonetheless, because it has always been possible for intra-corporate disputes, but we have a very clear framework only since 2003, let's say. There was a transitory phase, so I think that it is all in all probably growing a little. What I can say is that I think that its destiny is to be concentrated in Milan, because you have really serious problems with, let's say, ad hoc arbitration for a matter of costs and uncontrollable quality of decisions. That's a problem, because either you go to very, very specialized, and you put in the clause you put very high standards, but then that selects too much, and it's probably excessive for small companies. But also, I think it's the legal framework is clearer now. It's getting clearer. It will get even clearer with the reforms that are planned. So I don't think that it's let's say it will immediately let's say decrease. However, it is actually let's say ordinary justice is definitely more competitive now vis-a-vis arbitration. I think that arbitration in company law has not been is not sufficiently discussed, because you have to choose it in the charter, in the Articles of Association. I don't think that there's enough reflection of people who write the charters with the arbitration. The process of writing charters lies for the majority of companies with basically accountants in Italy, and they put in these clauses just because they find them, because let's say the business association suggests them, and then they put them in. I don't think it's something that is sufficiently discussed at the moment of incorporation. As for the role of the Tribunal of Milan, well, so how the divisions were born. They were born by just creating a new competence territorial and creating these divisions. Milan already had a leading role, of course, and usually tribunals, bigger ones, are already organized by subject matter. So what happened is that the Tribunal of Milan already had, let's say, a specialized de facto section that became officially the corporate division, and so it acquired a leading role naturally. But I think the big difference as compared to Rome, because Rome discusses a lot of cases too, less than Milan, but a lot, is that they publish all the decision, also the interim decisions, all of them, the whole body of decision, and this makes a big difference because you can see the patterns, you can see the facts. They're mostly very similar, the case, and which you can't see in other tribunals. So other tribunals will not cite so much because you usually cite only upwards, let's say. So you wouldn't find, but they would say follow that kind of doctrine, those doctrines. Yes.
Yeah.
Thank you. Thank you for the question. And it is true that I guess in the beginning, when the court was created, there were two different scenarios how to regulate these issues. I remember that during the conference there was a representative of the United States, John Kerry was at that moment a speaker, and he said that in the United States, for example, every court is an anti-corruption court. So, but the path, I guess, the Ukraine went by creating a separate court was because of the much attention from the foreign audience and from the investors to show that we that Ukraine takes effort in this respect. Although I think that it is not a universal solution to create a separate court for such type of disputes, because if the judicial system functions well, I guess criminal courts would be and judges who resolve cases in this case in this field would perfectly do their job. So I believe, of course, substantive law is maybe not as important as procedural here, and I also agree that the substantive regulations are, as in Albania, they maybe have the same effect as creation of a separate court. As for the results of the court, I have to say that the Supreme Court and this new court which was created, they pay a lot of attention to media coverage. They try to show the results on conferences, in different speeches, by different given interviews on YouTube, and one of the things they are the administration of this court, what they are proud of is that they have 14% of non-guilty verdicts. So the problem which I'm aware of with the criminal proceedings in Ukraine, that was always that judges often agree with the prosecutor, and they have this pattern of cases, and attorneys have always tried to break this tradition. So the fact that we have some non-guilty verdicts is, I guess, it's a positive thing. In general, there are around 45 during the 2 years of activity of this court, around 45 guilty verdicts taken by this court. So, well, I hope that it will show positive results in future.
On this issue, corruption courts in Albania, where I've spent 18 months of my life in the Ministry of Justice, very valuable 18 months. And one reason, I mean, corruption is a problem, but one should not forget two things. First, the accusation of corruption is a political weapon as well. It is not innocent. It is, and that's why I agree that a certain number of non-guilty verdicts is a very valuable sign. And the second one is, I mean, it's nice to say that judges have a corruption problem, but then it is the responsibility of the state to make it possible for them to earn a decent living with their work. And that is something where I have my doubts that in some countries that is really true. And then, of course, it is even less surprised that these problems arise. So I think that you've got a lot of screws you have to turn in order to get that things right. Sorry for the interruption. Questions or remarks? Yes, please.
One short question about the concept of this statutory auditor in a joint stock company, because both of the speakers, Andrea and Ivan, you mentioned the concept of having the special auditor. It is somehow related to what was mentioned in Roy presentations before, related to the access to books. And the question that I wanted to ask is, what is the practice of the application of these provisions on the special auditor, both in Italian and in Ukrainian law? Because we also have a similar, as Ivan mentioned, we also have a similar concept in the Polish Act on the public offering. But I just wanted to ask whether it is a tool that's useful and valuable in your legal systems, and is it a frequently used tool, and is it an efficient instrument for the minority shareholders to enforce the rights, or to at least to enforce the right to information?
Just to piggyback on that question, if I may, are there any provisions to avoid abuse of the right to ask for a special investigation? Because our experience is that it can be used for abusive purposes as well. Andrea and then Ivan, please.
So this procedure was used before there was a derivative action. It was the only means of minority shareholders, and so it was used for closely held companies and for all kind of companies. Now, basically, for all the LLCs, you don't use it anymore because you can sue directly and obtain the revocation. Is the only way you can obtain revoking the directors in removing the directors in joint stock companies. To my experience, there have been a few cases, very few high-profile cases with listed companies. One was the Fondiaria Sai case that was egregious. It was an incredible matter of all kind of related party transactions. There have been certainly another few I can't remember. But that is interesting that we never had one single derivative action since its implementation for listed companies since 1998. So you do have it for closely held companies, both LLCs and joint stock, but never one for listed companies, publicly traded. Whereas instead this inspection works. And as regards the abusive practices, you have a kind of a two-phase process in which first the tribunal sees if it has some grounds, and then and only if it has ground it goes on. And also what has changed is that now for only for listed company, also the public prosecutor can ask it, whereas before it could do it also for closely held. And so what happened is that minority shareholders that did have standing asked the public prosecutor, because in that case, if the public prosecutor asked, the tribunal would say yes, let's say, and would also have the expenses of the audit on the company rather than the minority shareholders. So I think it kind of works altogether. And it does still substitutes a little the derivative action for listed companies, not instead for the LLCs. It not really disappeared, but almost.
Thank you for the question. I have to say that from the beginning, when the corporate laws of Ukraine were designed, we saw that courts were somehow distanced from such appointment proceedings, as opposed to how it is done in Germany, in Poland, and that is why I'm not particularly aware of some famous cases where such appointment was the subject. I know that in the 2000s that there was the whole wave of raiders attacks, and they were using different means at that time, including information requests and such requests for auditor. I'm sure that so this right was abused at that moment. That is why I believe that it is not it is not so well maybe regulated in detail, and maybe there is still not much faith in this instrument as an instrument for minority shareholders protection. But I believe that from the point of view of future perspective, it would be good to improve the regulation by including these consequences of how it is considered. So it is so far it is quite toothless, I would say.
Just a short question to Professor Zorzi.
The mic, please.
Thank you very much. Just a short question to Professor. Right now it should work. Short question to Professor Zorzi. Please correct me if I'm wrong, but I understood in your presentation that in Italy you cannot get an injunction before arbitration court. And in such cases, you get no injunction at all, or you need to go to the state court in order to get the injunction?
So you need to go for injunctive relief in general. You have to go to the state court. You can. What you can't do at all is obtain an immediate payment order. So if you can obtain it, but then if the counterparty countersues, it is automatically voided, because you cannot resort to either it accept the jurisdiction of the judge, or if it says that it's an arbitral matter, then it is automatically revoked.
Okay, so if there are no further immediate questions, I suggest that we leave it there. Do we take a break? Do we continue immediately?
I think we have now a lunch break, right? Olga?
Yeah, let's take a 15-minute break.
A 15 minutes break, so a quick one, and then we continue here at 10 minutes, 20 minutes to 2, I'd say, with the next panel. Thank you.
Thank you.
I got ordered to start. I want to welcome you to this panel. My name is Manfred Gröninger. I'm working with the Division Banking and Insurance in the Austrian Chamber of Commerce, and it's my pleasure to introduce Ariel Mucha and Christoph Lack. Just a few words in all dignity and shortness. Ariel Mucha is holding a PhD in commercial law from Jagiellonian University. He's also an assistant professor at the Institute of Law and Economics at the Biological University of Krakow. He is also a researcher. That's very interesting and good, and also legal advisor. So he's also in practice, and also was a certified advisor with the New Connect Trading Alternative System at the Warsaw Stock Exchange, and he is going to give us a lecture as regards injunction remedy in corporate disputes, the Polish perspective. This also is yours, Ariel.
Thank you, Martha, for this kind introduction, and thank you to the organizer for convening this fantastic, thought-provoking conference. And yes, my topic will be injunction remedy in corporate disputes, the Polish perspective, and I will concentrate only on injunction issued by the state court. So this is very important thing for business, as we already heard from Andrea. Injunction allows a person whose right was breached or abused to. I hope that the presentation will be work because it's very valuable for me. So injunction is very important because this allows a party to be granted a temporary protection before the final decision is made in the case. So this is obvious for all of us, but injunction as a proceedings has some disadvantages, and one problem with injunction is the fact that the court is not allowed to conduct all evidence, and there is some problem sometimes with accuracy of the decision, and this two things will be of most importance for me during my presentations, so speed and accuracy. And okay, I'm just waiting for presentation, so maybe I will slowly move forward and maybe that will appear. And my plan of the presentation consists actually of 2 points. First, I would like to, okay, it's working, okay, we are here. 2 points. First, I will make general remarks on injunction relief in Poland, and the second thing, I will present my empirical research. So it is basically a research of all the rulings I could find in the Polish legal system. There are over 100 decisions. I analyzed, read the opinion. I really would like to present you the results, but okay. I hope that it will be working. At the final stage, obviously, there are conclusions in relation to the main issue of this conference, so specialized court. Okay. Okay, general remarks or interim remedies in Poland. There are no specific provision in corporate law, in corporate code as regards interim measure. There are some exceptions, but they bring more ambiguity, complexity than explain anything. So if the applicant in Poland want to get an interim regime in a state court, he must refer to the provision included in the civil law procedure code. And basically there are 3 main conditions, 3 main premises. First, you must substantiating lend credence to your claim. So basically it means you must persuade the court that you, at the very end of the proceedings at court, you will successfully receive an award. And the second thing, you must demonstrate a legal interest in granting relief. And that means basically that you must show without an interim relief something bad happened to you or the interest of the company. In fact, you must just explain the court what is going on in the case, because sometimes there are problems with understanding as in that regard. And the third thing, proportionality tests. So the court is looking if the entitled person is protected, properly protected, and on the other side that the obliged person is not overburdened by the injunction in question. So those are three general conditions for issuing an injunction under Polish law, and there are some other aspects I would like to share with you. The first thing is the model of injunction. We got ex parte injunction, which means that the decision is made without presence of the defendant. So the situation looks like an applicant is filing a case, requests an injunction, the court takes a decision, and then the decision is sent to the defendant, basically, and only then he has chance to prove that this injunction was wrong or made under wrong conditions. And the second thing, which I found very important, that maybe injunction is temporary, but the effects sometimes are perpetual. What does it mean? For instance, if we get an injunction that causes that the current board of directors are basically kicked off from the company, it also means that the former director are reinstated. So they are chair, they are manage the company, and all action that are taken by this reinstated directors are fully effective, even though the final judgment, for example, will be after all set aside or decided, final judgment will be opposite to what comes from the injunction. Okay, and there are, I mean, I read, as I said, more than 100 courts' opinions, so there are many different conclusions that could be brought today before you, but only some wisdom from the case law. In just to translate this rather long statement of the courts into short rules. So one thing is that you must prove your case and lend credence to the court, persuade the court, rather by documents. There is no opportunity, no space and time to propose hearing of witness or expert testimony. And that's sometimes a problem. There's one case I read that the court said that I will not issue an injunction because I need an opinion of an expert. And so the expert is not allowed in these proceedings, so I must dismiss your case. Another thing, when we got injunction addressed to directors of the company, there is a huge question, and the opinion of the courts in Poland differs in that regard. One court say that it is enough to show that the resolution appointing a director is wrong, and this is sufficient to issue an injunction in which there is an order for directors to stop managing the company. And there are also others decisions that shows that you must prove that this wrong appointed directors do something wrong, do some harm to the company, and this is not sufficient to show only that that they were appointed in the way of invalid resolution. And what also may be observed from the case law in Poland is that the serious case is, the more evidence you must bring with you to the court. So basically, in case of public companies, there must be some strong evidence, some strong document showing that your case will be successful after all in the grand finale of the proceedings at the state court. And injunction, I mean, injunction is very general idea. I found after the lecture of the whole decision more than 20 categories of injunction. They are addressed to the different addressees, different subject, and there is no time to explain all of them. I must just stick to the one remark that the most popular injunction is injunction related to resolution. So simply to suspend the enforcement of the resolution, and it comes from the fact that the Polish Polish corporate governance model concentrate around conflict between shareholders, so-called horizontal conflict, and that's why this kind of injunction prevails in practices. Andrea said it's also a case for Italy. Okay, so that was kind of the introduction to the Polish legal system, and now data, and the research question I wanted to answer by conducting a research. So my research question was how courts in Poland are prepared to resolve corporate law cases in specific proceedings, so proceedings for issuing an injunction, and this kind of proceedings is marked, as I diagnose, by asymmetry of information. So as I said, there is a problem because we got ex parte injunction, ex parte proceedings, and the second thing is time pressure. Normally courts should take a decision in the frame of time 7 days. So this is general rule for the first instance court. So, and why those two things are important? Because this is like a general truth that under time pressure and when there is an asymmetry of information, people usually make intuitive and instinctive reactions. So this is the best way to check if the Polish judges are well prepared to resolve corporate disputes. And in order to answer this question, as I said, I analyzed more than 100 cases. It translates to more than 170 decisions, out of which 70 cases were decided by both first and the second instance court. Okay. So what sort of cases? As I said, the most popular cases for issuing an injunction is the case of declaring a resolution of shareholders meeting invalid, and this is the case for over 70% of cases. Other types of sort of cases are exclusion of shareholders, liquidation of the company, and sometimes agreement between shareholders. Maybe one thing about the methods, because this is not obviously all cases, this is over 100 cases. In Poland, there is no obligation to publish a decision by the court, which is quite obvious, I think, for many jurisdictions. And there are also no incentives. So court may, but not must, publish a decision. It's really hard, and I really struggle for 2 months to find this 100 decision. Okay, so let's back to the data. Okay, this is complete. And forms of companies. The most involved type of companies in the insolvency proceeding is LLC, Polish spółka z ograniczoną odpowiedzialnością, and no wonder, because this is the most popular form of the company in Poland. However, when we go to the joint stock companies and public companies, we see they represent almost 1/3 of all cases analyzed by me, and that's a kind of overrepresentation, because in overall population they stand for about 2 to 4% of all cases. So, that can be followed through this diagram. Okay, speed of handling with with cases. As we see, the first instance court is quite speedy as regards dealing with these cases. The average in this case is less than a month, actually 2-3 weeks. So the first instance court are quite effective when it comes to the speed of handling cases. But if the verdict is challenged by the other party, or by the applicant if he was dismissed, the time extend to almost 5 months. And this is because the second instance, there is a change of the rule of games. Simply in the first instance we got this ex parte proceedings, but in case of the second court we must inform the defendant, give him a time to challenge, and so on and so on. There is also no exact rule how much the second court instance can he must issue a decision. As I said, in the first instance court, there is a rule 7 days. Okay. Obviously, there are also cases for which last more than a year, but it's far from the aims of the injunction. Okay, and now reversal rate, and this we know now that the first instance court are quite good as regards the speed of resolving the cases. However, I also wanted to check how effective the courts are by measuring so-called reversal rates. And this reversal rates answer to the question how many judgments of the first instance court have been changed in appeal cases. Actually, it is some wrong. I mean, this is not how many has been changed, how many has been upheld. So yeah, slight difference, but very important in this case. And just for the first bar, and the first bar stand for reversal rate for general commercial law cases. So it includes not only corporate cases, but also sales of good contracts, and so on and so on. And in this case, the reversal rate equals to more than 58%. It means that 58% of cases was upheld by the Court of Appeal. Going to the next two bars, the second one is also a reversal rate for general commercial law cases, but without injunction. And as we see, is quite lower, a bit lower, about 1 percentage point. And when it comes to the cases only dealing with injunction, the rate is higher. So it means that the court are more effective when it comes to the injunction. And I think that this comes from the fact that this is also true for other kind of cases, not only commercial law cases. It simply means that the standard in the injunction proceedings is lower. It means that the court of the higher instance is less restrictive, less strict towards the decision of the first instance court. Well, okay, and this the first three bars comes from the official statistic of Minister of Justice. Two next comes from my research. And as we see, reversal rate for corporate injunction is lower. It amounts to 57%. And this is not a huge difference, but when we come to the reversal rate for joint stock companies injunction, including public companies, this rate hits the low. Only 33% of cases are upheld by the upper court. So it also means that almost 70% of cases are set aside or reverse changed by the upper court. And just for the benchmark purposes, the RRG bar stands for all cases in Poland. So it equals to 63% effectiveness, we can say. And the last is the top rate, almost 70%, and this stands for labor law court. I have no idea why the labor court is so effective. When I, as a practitioner, go to the labor court, I just don't understand what they are saying to me and how they are dealing with the cases. So, yeah, I just left this as only a benchmark. And you may think that this reversal rate is not high because maybe when the injunction is issued, the court is basically rely only on the statement and evidence presented by one party. And we can expect that the other party will come to the proceedings. He will show something new. And as a result, the higher court must react, must change the decision. And I read the opinion of the appeal courts in Poland, and as you see, only in 27% of cases there were something new brought by the defendant during the appeal proceedings. In 73 cases, the main reason for setting aside or modify the decision was an error of the first instance court. And some errors were really embarrassing, I would say. So the Court of Appeal said that the court of the first instance didn't understand the case at all. He drew a completely wrong conclusion, or he used injunction that could not get anywhere. Is a counterproductive order in such a case. So yeah, that's quite interesting. That the problem with first instance court is not about the novelty brought by the second party, but by the errors committed by the first instance court. And going to conclusion, and with some reference to the topic of this conference, so in my opinion, courts in Poland act as mediocre gatekeepers. They are quite good with blocking some ridiculous, completely wrong application, and are quite time effective in relatively simple case. But they show lack of understanding of key issue in cases, show lack of confidence because they require more evidence than in other civil disputes. And what was said also today, they meddle much more in procedural rules rather than the core issue in the case. There's also a problem with consistency of injunction. As you saw, there is more than 20 categories of the contents of injunction because there is lack of centralized court which would control the consistency of all of this decision, and that's why there is a variety of approaches taken by both the district courts and the courts of appeal in Poland. And final conclusion, in more complicated cases, like in cases involved directly or indirectly joint stock companies, courts struggle the most, and I think that specialized court is at most needed for big companies. Thank you for your attention, and I wait for a Q&A session.
Thank you very much. Do we allow questions right now, or are we proceeding with the second lecture, Marek?
Second.
Okay, then it's my pleasure to introduce Christoph Flack, who holds a law degree, also again from the Jagiellonian University, and also Yes, he's completed his studies in economics, so you're a lawyer and an economist, and you also are a member of the Bar Association of Krakow, and you also provide specific legal services for capital market stakeholders. That's very interesting for me, coming from the banking section. And you also advise clients on strategic consultations and negotiations for capital market transactions, and you're giving us a lecture as regards pursuing claims of investment fund shareholders in Poland, also again an empirical study. And the floor is yours, Christoph, and we are looking forward.
Thank you very much for your introduction. Thank you for the invitation to this conference. What I want to present is results of studies, empirical study on two groups of cases in Polish courts. There are both claims of owners of the investment fund shares in Poland. My presentation will comprise from the description of the cases, of the case studies. I will present my conclusions and the possible solutions that, in my opinion, are worth to be implemented in Polish law. I will start with some kind of executive summary that will key points of my presentation that will give your quick insight what I will talk about. Main reasons of problems regarding claims of owners of investment fund shares in Poland are, in my opinion, the complex legal structure involving investment funds and companies managing these funds, inefficient court proceedings, and the fact that courts, judges, and also attorneys are not specialized enough, in my opinion. Quick insight into how the structure of Polish investment funds looks in Poland. So as a general law, we have this. Sorry. Excuse me. I think it's kind of problem on my side. Oh, sorry for the problem. So, excuse me once again. So there are investment funds, there are separate legal persons, and there are also the joint stock companies that are managing these investment funds. It seems kind of obvious that there are separate legal persons, but in practice, as my case studies will show you, that's not so obvious. In my case studies, there are two types of investors' claims presented. The first one is the regular litigation for damages or for reimbursement of undue payment, other undue earlier delivery or performance. Yes, and the second one is the injunction that was extensively presented by my honorable president speaker. Another background that should be presented, in my opinion, is that I will skip the precautionary measures, so-called this proceeding that leads to injunctions, and what I want to present is how the current situation regarding competent courts in financial market cases looks right now. There are no specialized courts that are dedicated to the financial market matters. There are commercial matters courts that are relevant when the claim is against financial institution is made by entrepreneur, and there is also a special department of Warsaw right now of Warsaw District Court that is relevant in claims regarding foreign currency credit agreements, and there are also some semi-official expertise areas of judges. Assignment to the courts, department of the judge can be possibly changed, so the expertise areas are rather fluent. I want also to present the situation how the lawyer services, the specialization of attorneys look like. There are two groups of attorneys, but the division is resulting from the past circumstances, and there is no real difference right now between them. They are called Polish names adwokaci and radcowie prawni. Other lawyers are also on the market, but mostly for non-court actions. There is no official for the attorneys. There is no official expertise areas. No official specialties, excluding tax attorneys and patent attorneys. And also, what is worth mentioning, in my opinion, that excluding Supreme Court proceedings in administrative cases, there is no mandatory representation by an attorney in court, which also brings us to the situation that there are more possible mistakes when the investors are acting on their own. The first case study, it's disclaimer at the beginning. These cases in both studies are cases that are where the clients, some parties to these cases are represented by me. So the information that I can give from on the one hand, it's more. I have more information than it's officially known, but on the other hand, I'm obviously under this professional secrecy obligation, this so-called client-attorney privilege. So what can I say? It's kind of limited. The first case study, what is about? The cases are about investors' claims against the investment management company, that is managing investment funds. Also, in some cases, both, and in some cases, separate investment funds. So separate legal persons under takings for commercial, for collective investments. And also, in some cases, depository banks are involved because they, in some kind of special circumstances, can be responsible for managing an investment fund. There were, from approximate 20 cases, I took about 10 similar litigation cases. They first of them started in 2019, some later. Most cases they are still pending. What's the results of this case study that I can present? The errors that are frequent in these cases can be divided into three groups. The most frequent one is which entity should be sued. the difference is between, in most cases, between investment fund and the company managing fund, investment fund. In my opinion, in circa 90% cases regarding at least one of claims in each lawsuit, there was a mistake in this. It could be in two versions of this mistake. The first one is when only the improper entity is sued, and the second one was then from this so-called trying to not make a mistake, the applicant sues both the investment fund and the investment fund and the company that is managing the investment fund. Also, what was identified as a common mistake was the situation, the question of which entity a document should be filed with on the pre-trial phase. The good example, the most common example is the statement regarding avoidance of legal effects of a declaration, a contract. Almost in half of cases, some kind of mistake of this type was made. And the list one mistake was made about the incorrect entity indicated on the power of attorney document. Who was responsible for these mistakes? There are few groups. Of course, attorneys may be acting in some cases on the demand of the client. Also, when there were some cases when partially or in the whole case the investor was acting on their own without an attorney, and also let's say courts, judges made some of these mistakes. The real outcome of these errors, because the most cases is still pending, is right now not clear. It could lead to several negative consequences. Of course, losing the case or claim withdrawal when the situation about the losing is already clear for the plaintiff. Also, the negative consequences could be that the limitation period for bringing claims against an appropriate defendant could expire. And in some kind of situations, like the mentioned earlier, bad indication of bad indication of the proper entity on the power of attorney document, it could lead to mistrial, nullity of proceeding under the Polish civil law procedure. That's all about the first group of cases. The second case study is about approximately 30 almost identical cases, examined applications for injunction for precautionary measures. They are all ended, at least in the first instance. They all involve the situation when the investors are going after investment management company. Approximately 13% of all motions were granted in first instance, but what's interesting in my opinion is that the different approach depending on the level of court, because some of the motions depending on the value of the claim were filed with were filed with the court of the lowest level in Poland, and in this situation, 2/3 of this motion was granted, and when the motions were filed to the higher level court as the first instance, no motion was granted at all. As the preceding speaker has mentioned, that there is a term of there is a deadline of 7 days when the injunction motion should be decided in the first instance, and the average in this group was quite higher, but the median was quite good. But what's also worth mentioning, in my opinion, is that not only this decision which is made in court's chamber is in court's premises is when it's made there it's important, but also it's important from the practical point of view when the writ from the court is delivered to the party, to the applicant, because in case the applicant wanted the injunction, it's almost every time it's important to them to get it rather sooner than later. So in this also what's important, that the delivery of the court documents should be efficient, not only when the decision is made by the judge, but also how efficient the clerks in court works when the document is available for the applicant, which also implies when takes effect on when the judgment's reasoning is made and the appeal procedure can be started. There are also, in my practice as an attorney, was some kind of similar cases that are not in these two groups, but also shows that there are frequent errors on the side also of judge that are kind of obviously wrong, but it's rather no effective countermeasure against it than the standard appellate procedure. What are the possible solutions, in my opinion? I think that the highly specialized court department and judges are something that should be done. I want to also indicate that the kind of comparison between the court judges' authority and the authority of administrative bodies, where the administrative bodies are highly specialized. Let's say the Polish Financial Supervision Authority is specialized authority in regard to financial matters within the administrative part of authorities, and in the court section of authorities there is no such specialized court. Also, what's from the experiences from the representing clients in courts in the last few years shows that there is increasing need for electronic document management and delivery systems in courts, and also electronic online-only court hearings. There, for example, from my experience, I can say that it works quite well in Polish district court in Warsaw, where this kind of hearings are, I think, right now more frequent than the standard on-site hearings. And I think it's a very efficient solution. Also, what in my opinion could be because some of the mistakes that I have mentioned earlier are made by attorneys. I think that postgraduate certification of attorneys, official or not official, let's compare it to the financial market solutions as the institute that issues CFA and other kind of like this certificates. I think it's a good solution that letting the market regulate themselves. It's pretty often also a good solution. There is today at the area the speakers that that were presenting their the materials earlier introduced also the possibility of mediation arbitration as a solutions. I think in the Polish in situation of Polish market, the first thing to made it more frequent use, the arbitration and mediation, is building a trust among investors, because from my experience there is kind of a big distrust, especially from the individual investors towards mediation arbitration, and maybe kind of education and in this matter, and PR actions that make the mediation arbitration more attractive to individual investors could make a difference in this matter. I think it's all, but thank you very much.
Well, thanks a lot, Daniel and Christoph. From a pure Austrian potential investor perspective, I'm not sure whether I should be very happy with all this new information or whether I should be just a little bit less happy. But as regards the big Polish market, and as I'm also a little bit involved in an interested person in some of your financial market cases as regards foreign loans.
Maybe you are talking from the Raiffeisen's point of view.
No. I'm just very interestingly looking at the decision of the European Court of Justice. I would have some questions, but I would like to open the floor. Please.
I have a question and a remark for Ariel Mucha. The first question is just the reversal rates, being that 60% of first instance decision is changed.
No. That was error.
Okay, so
in the presentation.
Yeah. On, let's say, did you take only the appeals, or did you follow? I mean, because you could have actually a bias in the selection, in the sense that if a case is very well decided, then people don't even appeal it. So if you do, sorry, is it not wrong?
No, it's not.
Oh, sorry, it was green. So I'll do the question again. Yes. So the question was on the reversal rate. I was just wondering if you follow all the first instance cases to the appeals, or does the reversal rate only refer to the appellate cases, in the sense that if a case is not appealed, perhaps it was correctly decided, and so that so that was a first question. And instead, then there's a remark that you say there was a slide in which you said that judges require more evidence in corporate disputes, basically, and that's interesting because. There was this paper by Luca Enriquez about 20 years ago saying that judges tend to be deferential to controlling shareholders and directors, and he made various examples. And I just didn't test it now. I would say that perhaps in some cases there is still some deference, but the specialization of courts has definitely taken away from this deference. Asking for more evidence is also a procedural way to say, when we are not sure, we rule in favor of the management or of the controlling shareholders. So I just wondered if that could be a possible interpretation of the result.
Yeah, this reversal rate, in the denominator, there are only cases which were brought to the appeal. So they are not included all cases, and this is follow the methodology of the Ministry of Justice, because the rates for the courts in Poland are normally higher if you include all cases. So I have knowledge of the court in Krakow. The reversal rate, general reversal rate, is more than 90%. So 90% of cases are held effective, they are not reversed or set aside. But in this case, I showed on the slide, there are only cases that was brought to the court of appeal. So the sample is smaller, simply to say. And when it comes to this evidence problem, I mean, this remark is based on my practice. In normal cases, in normal civil cases, there are plenty, I would say, possibility to persuade the court, and sometimes even sufficient is to say that during the hearings, the witness will say something. Yeah, and for a court in the normal civil cases, sometimes it suffices. In cases of this corporate injunction, there is no way. There's few decision. You must prove it only on documents. From the documents must follow that there was something wrong with the resolution adopted by the shareholders meeting. So I would say there is less trust in corporation among Polish judges. So.
Okay. I think I will do the microphone. I found it very interesting that in ex parte injunctions, the counterparty is not heard at all, and that the injunction is done in 7 days, and then it takes an average 5 months to get the injunction removed. Isn't this then a very powerful weapon which can be abused to a large extent? And what about damages if it is abused? Is there any evidence in Poland? I find this surprising because that is not our Austrian rules, where even with ex parte injunctions, the general rule is, not always, but the general rule is that the party has to be heard, the counterparty. Only in exceptional circumstances, the court may forego such a hearing for the counterparty. For instance, if there's a danger that he absconds with the money before, if he knows that an injunction is on the way. So I was wondering, I find this very dangerous, to be honest. Thank you.
Yeah, I agree completely. I mean, I know one case. There's a client attorney privilege, but I will just simplify this case. So the case was like this. There was a director which was removed, and he made an application for an injunction that the resolution dismissing him is invalid. And the court, based on his statements, agreed with him, and he waited on the premises of the company to collect this decision. And he didn't say anything to other directors in this company. And that's why the decision was final. There was no appeal. And through, I think, 6 months, he started to tunneling assets from the quite big company. Completely agree, there's much risk with this model of injunction.
What was intriguing from my point of view. John, please. Right now, it should be okay. Okay. So what I found intriguing was that small reversal rate with respect to joint stock companies, and I was wondering what's the reason for this. And the only idea I have is that the joint stock companies are usually on the side of the defendant. They are bigger organisms, and so they have more financial assets, so maybe they have better financial assistance. But do you find any other reasons why that reversal rate is so significantly lower in case of joint stock companies?
That's a really good remark. I mean, I found rather that those cases were more complicated and there was much more opportunity to make a mistake. And that's why the decision was set aside, as I remember. But this is a good point. You know, the problem is with the opinion of the Polish courts. They are very rudimentary. There is no much information. Like 90% of the judgment is about procedure, about the facts in the case, and like 10% is the ratio decidendi. Sometimes I looked between lines to maybe find that there was other problem that the court saw but didn't disclose in his opinion. So, for example, court felt that he must reverse the case, but didn't find enough reasons at the law. But still, he was like he has feeling to it must be done in this case.
Martin, you had a question.
Sorry about that. Just very briefly to the same point, I was just wondering whether that's not a case of small numbers.
Yeah,
because it's 33.33%. That sounds like 1 out of 3 or 2 out of 6, but not of 17 out of, you know. So it seems to indicate that there's very, very few cases, and then it's probably not as reliable, the number.
Yeah. That's a good point. That was 20 cases involving public companies and joint stock companies. No, 20, 18. 80. So there is a very small number as regards sample. And from the statistical, that might be huge error on my side. But still, 12 decision was wrong by the court of the first instance. 6 was confirmed by the higher court. As I said at the beginning, the problem is that all those decisions are not published, and I had to base on what I found.
Did you also have some listed companies in your sample?
6 listed companies.
May I ask something and also ask something? I'm referring to Ari's presentation, and when we discussed first which topic you are going to cover.
Yeah, it was your idea, Arek.
We discussed this, and the conference is about specialized courts. This presentation was about corporate litigation, because there was, I think, no mentioning of the courts. But one of the background considerations why we actually started this discussion about specialized courts was precisely because of the need to have things decided quickly. In the corporate realm, to know who is the director, who is the shareholder. You have a meeting, somebody comes up, shows up, and you need to quickly decide. You have a public notary, but the public notary is not there to solve these questions, and also some other complicated questions such as suspension of voting rights because of violating some rules on acquisition of blocks of shares and so on and so on. And those are the things that you really need to have a quick decision. So this presentation, I think, illustrates very nicely the big need for a court that could, in a very competent way, very quickly address the core issue, because this becomes manifest that if you need to get it quickly, done quickly, you need to have someone who gets to the core very, very soon. And as you were telling us, Ariel, sometimes the court did not even recognize the core issue of the case before handing down the decision. This was a comment, and now is a question. My understanding is that you referred to the reverse rate, first instance of the injunction, and then having this injunction reviewed in appellate court. Now, but I think it would be quite interesting to see how things continued, how things unfold, and what was the final judgment on merits after the court heard the case entirely. And this would be also telling about the quality of these interim measures. Is this something that you already investigated, or is it something that you are going to investigate?
Yeah, I wish to have access to this kind of data, and this was my first idea to check it. But the problem is that only some injunctions are published, and the same as with final judgments. There's not like a court of appeal publish an injunction decision, and he is obliged to publish a final decision in the case. There are a lot of loopholes about data. So yeah, that's now this research was conducted through internet, but maybe I will try to go on to the court building and ask for documents for cases, but it would take much more time, and yeah, the courts are not friendly when it comes to such kind of research. I have some experience with that. So, yeah, but it would be great to have this information, but simply I couldn't find following results of each case in which injunction was issued at the first place.
Mm-hmm. So are there any further questions? Then I would have one last comment and one last question. I think both presentations really show the underlying foundation why you need to have such a specialized court, because you need to improve the procedures, also as regards digitalization. I mean, there are some EU directives as regards digitalization, and also now during the pandemic we see this push in digitalization in any case, whether it's virtual meetings, whether it's court procedures and so on, because with the qualifications of judges and also of attorneys, you need to create trust within the investor environment, because as you said it before, in the financial markets, also as regards financial markets authority, I mean, that's the interesting part of my job. Digitalization is really driving us at a speed which is unbelievable. And I would have one last question to you, Christoph, because on your slide as regards case number 2, you had a difference as regards the granting of motions in first instance. Once you had 13% and once you had 67%
Yes.
granted. I didn't get it, so maybe you could give me this last clarification.
Yeah. I'm glad you asked it. The first number, the 13%, is the percent which the general, the whole, let's say approximately 30 cases. What's the success rate in this general number? The second one was referring only to the. Also, I want to indicate that some of these motions are filed with the lower level court and some with the higher level court, depending on the value of the claim. And this 67% is the success rate in the lower courts, and in the higher courts there were no success. So it can be interpreted in it can be what the conclusion from it. I think that on the one hand you can say that the more experienced judges in the higher level court were better and better assessed that there is no good reasoning for granting this kind of motion. On the other hand, you can say that in the lower level courts, the judges are, how can I put it, more fresh ideas, open to different approach, and that can also lead to the judgment, in this case the granting the motion, that they found acceptable, but when this goes to the judge that is already 20 or he is not in the place that he wants to learn new things, etc. There are kind of examples like that, and that you can make this and you handle this kind of motion like the easiest way to get it done. Yeah? It could be viewed also as this kind of reasoning, how this different, there was such a difference between how the lower level courts act and the higher level courts.
Okay, thanks a lot. And one final comment, as I'm working on the implementation of the EU directive as regards representative actions, and this is also touching the financial fields from the consumer side. So I think there's something you should have a look to, because this is giving some additional implications as regards civil proceedings and courts. So thank you very much, and thank you. This panel is then closed. Thank you.
There has to be a 15-minute break because we're really behind the schedule. Yes.
Ladies and gentlemen, good afternoon indeed. I'm very happy that Adek has allowed me to chair the panel where he was initially to be the chairman. You know, during COVID times there are sometimes late cancellations. What happened in my case was not a late cancellation; it was a late confirmation, which only occurred Wednesday evening, and it was only yesterday evening where Adek kindly agreed to let me chair the last panel, and I'm very happy to be with you here. Let me introduce today's presenters in the panel. We have Ms. Jelena Lepetic from the University of Belgrade in Serbia. Jelena is a graduate of the Faculty of Law of the University of Belgrade. Currently she serves as an associate professor with this faculty. She is also Vice Dean for International Cooperation with the faculty. And Jelena serves also as a member of the supervisory board, if I recall correctly, of the Serbian Association of Business Lawyers, and at the editorial board of the journal Law and Economy. She teaches company law and bankruptcy law at several levels of studies at the Faculty of Law of the Belgrade University. So I'm happy to meet you today, and we'll be happy to hear your presentation. And the other presenter in the panel is Ms. Patrycja Gliwka, and I have a real pleasure to introduce Patrycja to you because Patrycja is a former student of mine. So I was the academic supervisor of her master thesis. I recall exactly the thesis. It was about the legal framework for the materialization of non-listed securities. It was a very good master thesis, and Patrycja is a legal professional, a graduate from the Warsaw University School of Law, and she works with one of Warsaw-based law firms which specializes in the financial market, in law of the financial market. She has been involved in advising investment firms, management funds, asset management companies, and she has also been involved in many proceedings before the Polish Financial Supervision Authority. So I'm very happy to have you ladies on the panel. I just had this week I had a seminar on ESG in Italy, so I'm also very happy about the fact that the panel significantly improves the gender balance of our today's event. So I'm happy to chair it. And the matter that will be discussed today in this last panel of our today's conference is a matter which is very close to my current professional interest, because being chair of the Polish Financial Supervision Authority, of course, I'm involved in issuing administrative decisions which are addressed to supervised entities, to the participants of the financial market, and the main topic of this panel will be the judicial control of the administrative actions taken by financial supervisors. And Jelena will provide us with the Serbian perspective, while Patrycja will provide us with the Polish, with some thoughts on the Polish system. So the floor is yours now.
Thank you. Thank you for this kind introduction. And first of all, I would like to express my gratitude to the Professor Radvan who invited me for this conference, and to congratulate him and his team for organizing on-site conference, which is very difficult in these challenging times. Today, I will speak, as you already heard, about the judicial review of the exercise of administrative powers by the Serbian Securities Commission. I divided my presentation in 6 parts. So first of all, I will start with some basic information about the Serbian Securities Commission, then about the administrative court, the control of the controller, then I will present some evaluation of the court practice and offer some possible solutions for the improvement and the move forward in Serbia regarding this issue. And finally, I will make some conclusions. So the Serbian Securities Commission is established in 1990 by the 1989 law on securities. Actually, this was the beginning of the end of the ex-Yugoslavia and the beginning of the process of transition from the social ownership to the private ownership and private property. And this is the process which is still not end. And even today, the process of privatization, it influenced on some decisions by by the Administrative Court regarding the decisions of the Serbian Securities Commission. So today, Serbian Securities Commission is regulated by the 2011 law on capital markets. But still, recently, very recently, only a month ago, there was a public debate on the new draft law on capital markets. Today, Commission is consisted of 5 commissioners. One of them actually is the chairman of the Commission, and up to date there were 10 term of services in the Commission. Our Commission is based on the U.S. model of the Securities Exchange Commission. The competencies of the Commission are various, so some of them I just make this division on normative competencies, as you may see, for example, enactment of bylaws, giving approvals, for example, of prospectus for public offering, granting permits for performing certain activities such as investment services, then educative competencies, for example, the organization of classes for brokers, supervision and monitoring, keeping registers and reporting, and initiating court proceedings for the protection of investors' interest, which is actually not used in practice, unfortunately, because this is a kind of organization claim, and there are no detailed regulation regarding this competence of the Serbian Securities Commission. And finally, there is cooperation with international organizations and foreign entities. The majority of these competencies are delegated activities, which means activities of the state administration which are delegated to the organization such as Securities Commission. The competencies of the Serbian Securities Commission are also provided for in other laws, such as, for example, law on takeover of joint stock companies, 2 laws on investment funds, and so on and so on. So the Commission actually applies the rules of the law on administrative procedure when deciding the administrative matters. And these decisions of the Commission are final, which means that there is no administrative control of the decisions delivered by the Commission, but only these decisions may be disputed, may be challenged before the Administrative Court of Serbia. So I just wanted to enlist these reasons when the decisions and conclusions of the commissions may be disputed. So only the administrative acts which are defined by a law on administrative procedure, general administrative procedure, and law on administrative disputes may be actually challenged before the administrative court. And these reasons are important because I will later on evaluate the court practice in Serbia. So first of all, these decisions and conclusions of the Commission, this may be a little bit tricky to explain because conclusions should not be always administrative acts, but sometimes they are. They are not always acts of managing of the procedure, and our law is not so clear about this, but in the court practice we see that that is actually so, that conclusions may be also challenged. If the law, other regulation, or a general act was not applied, or it was applied but the manner was wrong, when the act was delivered by the non-competent body, when the act was not delivered in accordance with the rules on procedure, when the facts were not found in the complete or correct manner, or they were the reached conclusion was incorrect. And the final one is when the body exceeded the powers conferred to it by the law, or the act was not delivered within the purpose of these powers, and this is actually the case when the act is adopted at the discretion of the body. So I will just now give an example and make a comparison, for example, to the acts delivered by the National Bank of Serbia. For example, in our law, which is regulating banks and national banks of Serbia, it is expressly said, for example, that the National Bank of Serbia has some discretionary powers when making these decisions. This is not so when it comes to the Securities Commission. But when we look into the provisions of the law on capital market, and not only that law, especially into the law on takeover of joint stock companies, from the wording of these provisions, we may also conclude that some of the decisions are actually delivered by the using of discretion of the Securities Commission. This is very actually important because of the review of the decisions delivered by the Commission, and I will explain that in more detail later on. And now I would like to address the Administrative Court, which is a court of special jurisdiction in Serbia, one of many, because we also have a commercial courts, we have appellate commercial court, we have a misdemeanor court, and we have appellate misdemeanor court. Actually, this is the court at the level of republic, and the judges which are appointed at the administrative court need to have at least 10 years of professional experience in the legal profession after passing the bar exam. That is the same number of years which is needed for the appointment at the commercial appellate court. So that is the equivalency, for example, the administrative court and the appellate commercial court. When we compare it, for example, with the commercial courts, which are the first instance courts, it is a 6 year less. So this means, 4 year less, which means 6 years of professional experience. At this moment, administrative court has 49 judges, but according to the newest decision on the number of judges in the Court of the Republic of Serbia, this number should be and will be present and 55 judges. And there were I have some striking information about the administrative court, that it is actually the most burdened court in Serbia. So the caseload is numerous and enormous, and the subject matter is also very numerous. For example, this court decides on the tax issues, election issues, some measures regarding the environmental protection. So these judges, they do not have any kind of specialization in capital market issue, in corporate, for example, law issues, because sometimes the borderline between these subject matters, it's not completely clear. So this court is actually established in 2008, and it started to operate in 2010. Actually, Serbia returned to its tradition because before the Second World War, the administrative courts already existed, and after the Second World War, the competence for resolving administrative disputes were actually given to the courts of ordinary jurisdiction. So that was the situation in 1952. So after more than 50 years, Serbia goes back to its traditional rules. So nowadays it's more than 10 years of the experience of the court practice before the administrative court. The administrative court may actually approve or reject the claim. In our case, this will be against the Securities Commission, so that will be our defendant. Of course, if it does not dismiss the claim, if it does, then the party may object to the decision of the court, and if this objection is approved, the dispute will be continued. So I really had an opportunity to evaluate all the judgments of this administrative court from the beginning of its establishment till today, because I have to say that we have a cooperation agreement with the administrative court, so this is not a sample. This, what I'm saying today, are total numbers. So I didn't check the dismissed claims. That's what I wanted to say. So these are all meritoriously resolved cases that I am addressing today. So the court, just to say this, may decide in the dispute of limited or full jurisdiction, and if the court is deciding in the dispute of limited jurisdiction, that means that it may annul the challenge decision and return it for the new decision. And this actually happened in the vast majority of the cases. Actually, from 18 cases where the claims against the commissions were adopted, it happened in 17 of them. And the other possibility that the administrative court may use is to decide in the dispute of full jurisdiction. That would mean that the decision of the court will completely replace the decision of the Securities Commission. This never happened. And what I also wanted to add, our court is in generally reluctant to decide in full jurisdiction. Why? Maybe it is sometimes really hard to decide whether the subject matter is actually the right one to be solved in that way. So our law said that the disputes may be resolved in the full jurisdiction only if the subject matter of the dispute allows it and if the facts which are found make a reliable basis for that kind of decision. And this is not possible when the administrative is delivered with the use of discretionary power. For example, if you have a supervision, if you have some imposed measure, of course that cannot be done, and the decision of the court may not replace the decision of the Securities Commissions. For 10 years till now, those are the data that you may see at the presentation, 18 claims were so adopted, 17 of them was returned now and returned for the new decision to the Commission. Only one time, one objection on the decision of the Administrative Court was allowed. So this case was not counted in the 41 total cases which are analyzed separately, and 23 claims were rejected. So you see, for 10 years, it is only 41 meritoriously solved cases, a really low number of cases. If I'm speaking about the percentage, it is 0.02% of the meritoriously solved cases in total. The totally solved meritoriously cases before the administrative court is actually 202,849 cases for these 10 years. So this is really extremely low number of cases, which is important for my conclusions, which I will state a little bit later. Also, what was interesting for me is that only one of all of these decisions, all of these 41, was delivered after the oral public hearing. This means that 40 decisions were delivered at the closed sessions. So the court used the exception because the rule is that you decide on the oral public hearing, and this is just the exception if the two conditions are met, if the subject matter of the dispute does not require direct hearing of the parties, nor the special facts finding also, or the parties actually expressly agreed to the closed sessions. So this was also one interesting information. Then I looked into the control of the controller, as I called it, so the control of the administrative court now. So now I have to add here that only the cases before the Supreme Court of Cassation are not a total in total number. So these are the cases that I found on the website on the court, and there are only 6 of them. So probably there are more, but not many more because it's 41 case in total. But also I checked what is happening before the Constitutional Court and whether there are some decisions of the Constitutional Court which are related to the Securities Commission's decisions. And I found 5 cases, and this number also is a total number because I also cooperate with the Constitutional Court. So those are the cases which were available to me. So only these cases before the Supreme Court of Cassation Commission are a sample. So I just wanted to clarify that. Actually, the appeals against the decisions of the administrative court are not permitted. And therefore, the law on administrative disputes prescribes for the extraordinary legal remedy. That's this motion for a review of the decision of the administrative court. So there were 6 cases, and all 6 cases ended in the way that all the motions were rejected. So the Supreme Court of Cassation actually confirmed the decisions of the administrative court. In that way, we may conclude that the first instant control is actually the most important one, and the improvements are needed over there. I will say why a little bit again later. Just for your information, I will deal with this in detail in my paper. I will not address case by case here, but in my paper I will. So these are the cases, for example, which were initiated by the minority shareholders, by an offerer who intended to undertake a takeover but was not allowed by the Securities Commission, and also one case initiated by the shareholders association actually. Only one of these motions was submitted by the Securities Commission. So that is again an important information. And what about the Constitutional Court? So these are all the cases of constitutional appeals. The constitutional appeal may be filed against the individual acts or actions of the state body or organizations which are exercising delegated public powers. When these acts or actions, they violate or deny human or minority rights or freedoms, only in cases when the legal remedies are not provided or are already used. So these 5 cases involve the judgments of the Supreme Court of Cassation, which were actually delivered as the submitted motion for review of the cases of the administrative court, and all related to the Securities Commission. What I may say for the Constitutional Court, this is really a low number of cases, but the role of this court was crucial for the protection of minority shareholders. I was also surprised because that court actually said that the minority shareholder is authorized to file a claim before the administrative court, so to initiate administrative dispute, if he believes, and he already addressed to the Securities Commission, to deliver a decision and to oblige the other shareholder, the majority shareholder, to publish a mandatory takeover bid, because this right was denied to the shareholders, minority shareholders, by the administrative court and also by the Supreme Court of Cassation. But the court found that this was not correct, that definitely the minority shareholder is the person who has the interest to initiate this kind of procedure, and that is the person which is protected by the law on takeover. He was not the party in the administrative procedure, but still, as a person with the legitimate interest, he may or she may, or the company may, of course, address to the administrative court. So only 2 constitutional appeals were adopted and 3 were dismissed. So there were actually 2 cases. I told you about the first one. The other case is not so interesting because it involved that case which I mentioned earlier with the shareholder association. It was again the authorization to initiate the proceeding, but because it was a legal entity, it had the right to direct access to the Supreme Court of Cassation without the attorney of law. So it has nothing to do, let's say, with these problems which I found in the evaluation of the court review, judicial review of the decisions of the Commission. So what is, again, an important information? So the incorrect application of the substantial law has never been a reason for adoption the claims against the Commission. So no claim was adopted because of the wrong interpretation and application of the substantial law by the Commission. What were the reasons for the adoption of these 18 claims from 41 in total, which I told you about? It was the violation of the rules on procedure and very prosaic reasons. A lack of minutes on deliberation and voting. The decision was not signed by the authorized person, so it wasn't signed by the chairman but by the other commissioner. The decision was not providing a clear explanation. The operative part of the decision was not short, was not specific enough, was not clear. And also there is another reason for the adoption of the claim. It was the improper, the founding of the facts in incomplete and incorrect manner. So this was a reason also for adoption of the claim, but much less frequently than the other one. And just to repeat once again, any of them was adopted because of the substantial law problems. Also, what was for me pretty shocking was that when the court was rejecting the claims, it did not offer any detailed explanation. So there weren't so much help for us researchers and scholars to see what is the position of the court. So we may conclude that actually the administrative court gave its trust to the Commission in most of the cases. Even when it was not the case, it didn't offer any detailed explanation, and it was needed actually. For example, for the definition of the persons acting in concert, for the price in the takeover. There were so many things that were actually applied by the initiator. What were the subject matters of these cases? It was mostly takeover, the majority of the cases. Some of them were related to the market manipulation. Actually, it was the supervision and, for example, withdrawal of the permits for some person, some market participant, or I don't know, some broker, for example, a license to perform these kind of activities. Then it was the violation of the rules of notification on major holdings. And what was also interesting, it was the imposing the payment of fee for supervision. And that is the decision of the Commission, which is actually delivered in the form of conclusion. And the court said that this is an administrative act which may be disputed. So that was the example that I was talking at the beginning of my presentation. So also there were two cases of silence of the Commission. That means that the party addressed to the Commission. It happened also with that minority shareholders, and the Commission was silent. They didn't deliver a decision. They thought that that person who addressed to them didn't have a right to ask for a decision, and these claims were also adopted by the administrative court. So I will now offer some solutions. So what can we do to change this technical and completely formal approach of the administrative court? Because of the number of cases, this has to be done at the first instance. Because before the Supreme Court of Cassation, there were only 6 motions for review, and this is also extraordinarily legal remedy. Again, Constitutional Court is not like a higher instance court, so we shouldn't look into that. But I just wanted to present you a whole picture. So the first solution would be a specialization of the judges in the administrative court. So it would be very useful to introduce training and additional education for these judges. For small number of these judges, I told you it is now 49, and there will be president and 55 of judges, and they deliver decisions in the chamber of 3, so a really low number of judges who would specialize the capital market issues would help to resolve these cases by applying also the reasons for the adoption of the claim because of the substantial law. The other possible solution would be transferring the competencies to the commercial courts. Actually, this solution was proposed in the competition law matters also. And the idea is to transfer the competencies to the courts that already exist. There are 16 commercial courts in Serbia, and their competencies are also various. For example, they resolve not only capital market disputes, but corporate disputes, then they resolve all the disputes between the business entities, such as companies, enterprises, cooperatives, entrepreneurs. They also conduct insolvency and reorganization. So their competencies are various, and they decide as the first instance cases. The disputes before the commercial courts are called commercial disputes, and they are regulated 34 of the law on civil procedure. And again, because somebody else also mentioned that it is a rule that you should use only the documents. It is not, of course, without any exception, but it is based on the documents to resolve these kinds of disputes. So it would be quite easy to transfer the competencies to the commercial courts. And the third solution would be to establish the special commercial court. I have to say that I am against this kind of proposal. Why? Because anyone can ask why, for example, capital market court and not corporate court? Where is the borderline? Why not competition court? So it will open so many questions and so many possibilities for establishing many new courts which are maybe needed. Or all these competencies may go to this same court, which then will not be capital market specialized court anymore. And also, I'm not convinced that this is the right solution because of the number of cases. As you saw in the last 10 years, those cases against the securities commissions are really rare, at least rare, 0.02% of total cases. And also the civil cases, they are not so numerous. I didn't do some detailed research, but for example, you should know that at Belgrade Stock Exchange, at the prime market, so the best market, there is only 3 or 4 companies. So I'm not so sure that we really need a specialized capital market court, especially having in mind that we have commercial courts. So I am actually against this solution, but I needed to say something about it. So for my conclusion, I just wanted to say why I am for the specialization of judges in the administrative court as a preferred option, and not of the transferring of the competences to the commercial court as the second best option. There are at least 3 reasons for this kind of conclusion. First of all, the cases against the Securities Commission, because this was the core of my research, are administrative cases and disputes in their nature, because the Securities Commission delivers these decisions by exercising its administrative powers, and this will not going to change in the near future. The tradition is the second reason. We recently returned to our tradition. 10 years ago, we established again the administrative court, and now we have to narrow its competencies and to transfer something to the commercial court. The third very important reason is the low number of cases against the Securities Commission. But I have also some disadvantages, and actually the arguments in favor of that second best option that I told you about, the transferring of the competencies to the commercial court. So the administrative court is the most burdened court in Serbia. So that is really a valid reason for this option. The commercial courts already do exist, which means it would be easy to transfer just these disputes to the commercial courts. And the third one is probably, I'm not sure if that is so, but it seems to me as a corporate lawyer that the specialization in administrative law is probably less demanding than the specialization in the capital market law. But still, there are a low number of these cases, and the administrative judges already saw something about that. And there has to be 2 or 3 of them from these 55 in the future, or 49, who may be additionally educated. So this is my final remark. So this should enable the judges to start reviewing the application of the substantial law when reviewing the decision of the Commission, and thus improve the position of the investors. I will conclude my presentation with that. Thank you.
Thank you very much, Jelena. I guess maybe it's better to maybe we should leave the discussion in the Q&A session for the last part of the panel, and now we'll have a chance to listen to the other presentation. I'm sure that Jelena's presentation has provided us with a lot of food for thought, which we may digest, and then we'll come back to our questions later after Patrycja's presentation. And Patrycja will provide us with her thoughts and comments on the judicial review of the Polish financial supervision action related to the investment fund market. So these are the decisions that relate to investment fund companies. So now I would like to pass the floor to Patrycja. Over to Warsaw, I guess.
Okay, I hope I am being heard. Am I?
We heard you before. Now we don't hear anything. But probably I don't know if you are speaking right now or not.
Yes. Can I start?
Yes, we hear you.
Okay, thank you. Good afternoon, and thank you, Professor, for this kind introduction. Unfortunately, I couldn't meet with you in person today, yet it is my utmost pleasure to join you virtually. And I'd like to thank the organizers for inviting me and giving me an opportunity to share my thoughts. And by contrast to the Serbian perspective we've heard from Jelena, I will be speaking on problems affecting the judicial review of the exercise of administrative powers by the Polish Financial Supervision Authority. And in my speech, I will provide examples of the judicial review of the authority's decision in the field of investment funds, since as we are here to discuss the concept of specialization of the judiciary system, I reckon that bringing the most specialized sector of the capital market, namely the investment funds market, makes it a striking case of the need of court specialization. Yet, starting with the common grounds for the judicial review of the exercise of administrative powers by the PFSAA, the authority exercised its supervision over the capital market, covering, among others, the supervision over investment funds, its management companies, and also other entities performing services for them. The authority within the scope of its jurisdiction adopts resolutions, including issuing administrative decisions and orders. And as a rule to the proceedings before the Polish Financial Supervision Authority, the provisions of the Polish Code of Administrative Procedure applies. However, the essential departure from this standard administrative proceedings relates to the appellate procedure. And due to the position of the Polish Financial Supervision Authority within the administrative structure of Poland, namely it is the central public administration body, its decisions are not subject to instance appeal, which would ensure this substantive verification of issued decision before appealing to the administrative court. But a party dissatisfied with the decision may apply to the Polish Financial Supervision Authority with the motion for re-examination of the case. The positioning of such a motion within the system of legal remedies admissible in the administrative proceedings in Poland has been the subject of doctrine discussion, aiming to treat it either as an exception to the principle of 2 instances or the way of implementing it. Eventually, currently both the Code of Administrative Procedure and the Judicial Administrative Procedure seems to treat such a motion as an ordinary legal remedy satisfying the criteria for implementation of two-instance rule, since it's also expressly codified that the decisions which are not subject to an appeal in administrative courts in the motion of this two instances, or also the motion for the re-examination are final. So it was also confirmed by the Constitutional Tribunal adjudicating that from the constitutional perspective, the motion for re-examination of the case is an equivalent to an administrative appeal, and the constitutional right to appeal against decisions rendered at first instance applies to it. So it also should be stressed out that in proceedings initiated by such motion for re-examination, the provisions on appeals against decisions apply respectively. Yet, in practice, such motion does not fully fulfill its verification function. In particular, in the case of filing a motion for re-examination of the case, the provisions of Code of Administrative Procedure on the exclusion of the body and members of the collective body who participated in issuing of the contested decision do not apply. And in this regard, we have the Polish Financial Supervision Authority Board being a collegial body with a permanent composition, adopting resolutions by a simple majority of votes, so that the exclusion of deputy chair of the PFSA's board and other members of the board from participation in the proceedings is possible by means of the chair's decision made at the request either of the party, a member in question, or ex officio, whereas the exclusion of the chair is decided by adopting a board's resolution. And while hypothetically it is possible that the exclusion of its members will cause that the PFSAA cannot deal with the re-examination of the case, and it's such a scenario that Prime Minister shall appoint another public administration body to deal with that case, yet such scenario is rather unlikely to happen. Also, statistically, the outcome of re-examination of the case is often identical to one contested. So, what is the alternative? Currently, appeals against the decision of the regulator, so also against the Polish Financial Supervision Authority, are examined by the Administrative Court in Warsaw, whose decision may be appealed in cassation to the Supreme Administrative Court. And by virtue of the 2017 amendment of provisions of the Code of Administrative Procedure and also certain other acts, the Polish legislature decided that filing a motion for re-examination of the case should not constitute a formal requirement that must be fulfilled before filing an administrative court complaint. So that party having the right to apply to Polish Financial Supervision Authority with a request for re-examination of the case may file a complaint against such decision to the administrative court in Warsaw without exercising the formal right. So, as far as judicial supervision over public enforcement of capital market law is concerned, Administrative Court in Warsaw is competent to review complaints against the authority's decision, yet the real problem lies rather in the scope of cognition of that court, since the adopted model of judicial review in Poland is, as a rule, cassationary. It means that court may only overrule the appeal decision and return the case for the re-examination, and it does not have the power to issue a reformatory ruling in which it would change the appeal decision and decide on the merits of the case itself. In other words, the decision of the public administration are reviewed by the court in terms of the compliance with substantive law and procedural rules, and not according to criteria relating to fairness of the decision and so on. And this also means that if complaint against a decision is upheld, the case will basically return to the administrative proceedings. And although the public administration body, in our case the Polish Financial Supervision Authority, will be bound with the legal assessment and instruction as to the further proceedings expressed in the court rulings, there is no guarantee that after the re-examination of the case, the party will obtain a favorable outcome. So by no means the judicial review of the decision is an equivalent to a substantive verification of issued decision. And further, a judgment or a decision that ends the proceeding issued by the administrative court in Warsaw may be appealed in cassation to the Supreme Administrative Court. This complaint may also be based either on the violation of substantive law through its erroneous interpretation or improper application or violation of the proceedings provisions of procedure, only if such violation could have substantially influenced the outcome of the case. So, as you can see, the model of judicial control over the authority's decision construed in such manner raises concerns, and that leads me to a couple of practical examples regarding the investment fund sector. Last year, the Administrative Court in Warsaw annulled the decision of the Polish Financial Supervision Authority regarding the imposition of administrative fine and withdrawal of the license to conduct the activity of the investment fund management company. It happened on the ground that the authority, in the court's opinion, breached procedural regulation to the degree that had, in the court's opinion, a significant impact on the outcome of the case. Also, the court upheld that the lack of the necessary findings made it impossible for the court to verify whether the substantive law provisions were applied correctly. Yet this ruling exposes typical to the cassationary model of judicial review urge to focus on formalities and the control of procedural regularity. Understandably, in any case, the substantive control by the court is limited. Needless to say that a significant part of administrative decisions that are issued by the Polish Financial Supervision Authority with this regard is based on the exercise of administrative discretion and not as a bound decision, so that court administrative ruling should aim rather at clarifying the framework of supervisory competences. As an example, clarifying the ground for imposition of an administrative fine on an investment fund management company, or precising undefined concepts, and here the cassation model of control limits this substantive control by the court. Anyway, the quoted ruling is not definite yet, and the PFSA's cassation will be examined by the Supreme Administrative Court in the future, so that may not be upheld anyway. Yet another thing is undoubtedly that both Administrative Court in Warsaw and also the Supreme Administrative Court lack sufficient specialization. And just as an example, the Commercial Chamber of the Supreme Administrative Court, adjudicating on cassation appeals in cases related to investment funds, exercises within the limits and in manner that is prescribed by relevant regulation, supervision over rulings of regional administrative courts in the matters of economic activity, protection, industrial property, budgeting, foreign exchange, securities, banking, insurance, custom duties, prices, tariff rates, fees. So here we have the complexity of capital market law and practices in force that requires the progressive specialization of panel of judges to input the enforcement of laws protecting investors. And judges who deal with other matters on a daily basis usually cannot foresee all the legal and economic consequences of their decision. And although my speech is dedicated to the judicial review of the public enforcement, lastly, as a vivid example of non-understanding of the specifics of investment fund activity, or more broadly, the specifics of the capital market, I will refer to the judgment of the Court of Appeal in Warsaw, so private enforcement for a few months ago, regarding the abusive clauses, where the court equated the participant of the Polish closed-ended fund, being an alternative investment fund, with the customer, and this fund's articles of association with a contract, so that in the legal relation of them, they applied exactly the same conditions as to any other commercial contract concluded with a professional end consumer. And such rulings appeal to me as another argument in favor of creating a specialized capital market and the need the capital market has for such specialization. And with this thought, I'd like to thank you for your attention and conclude my speech.
Thank you very much, Patricia. If I may, on a more personal note, I will share my thoughts, because that's one of the nice things about being a professor, that you may meet your former students in a conference panel, and even though you may not entirely agree with the view, then you may have a very good discussion and listen to a very interesting presentation. So that's absolutely nice. So if I may before moving to the discussion part and to the Q&A, maybe I would like also to share one of my thoughts on that, because maybe the more detailed questions that we may discuss in this connection, maybe there are some sort of a consequence of how we respond to a more fundamental question, which would be whether we want or whether we need to have substantive judicial review of this type of cases. Because what we may clearly hear from both presentations is that basically what we see in the courts is a review standard which is pretty formal, and I understand from these two presentations that there may be a need, or at least there may be some sort of a desire for a review that would be more substantive, that would provide the parties, the entities who are challenging the administrative decision with a next chance to have their matter re-examined on the factual basis or on the substantive law basis. And then the question is whether we want this or not, because if we want this, then of course this is a clear argument in favor of having a specialized court. This I acknowledge, but maybe we do not really need, or we do not really want such a level of such a level of scrutiny at the level of the judicial control of administrative decisions, which would then speak in favor of a limitation of the judicial activism. And if we go this route, if we do not want to extend the scope of the judicial activism, then probably it is pretty fine to keep this with the Court of General Competence. And it's also related to the question, or maybe to the comment that Roy Shapira made in his interesting intervention earlier today, whether we consider the court, or whether we want to include the court in something which we consider as some sort of a business community or a market community, because as I see it now in Poland, probably the PFSA, the financial authority, I can imagine this is also a similar case maybe in Serbia and the other jurisdiction, that the financial supervision is somehow considered to be a part, or I believe it should be considered to be a part of the business community, or a part of the market community. While I do not necessarily see that the courts the administrative court in Warsaw, for example, is considered to be a part of the market community. So, and whether this is a better solution, or maybe you should rather go this route of having the court as being also a part of the community, which then probably would make it more possible for the court also to exercise some sort of a substantive review. Personally, I have my doubts on this, whether this is the right route. I have only briefly touched upon this during my keynote speech last week. That the question whether we do want to have a public chamber of a capital markets court in Warsaw once we have such a court, it's probably a question how we see the need and how we assess the need of having a next layer substantive review of these cases that are dealt with within the scope of the remit of the financial supervision. And one more comment, because the title of this panel is in English translation, "Who watches the watchers?" basically, or "Who guards the guardians?" And the watchers or the guardians are, if I understand correctly, the financial supervisors. And the truth is that actually these are the financial supervisors who are some kind of like socially responsible and accountable for what's going on in the market. These are not the courts that are responsible and accountable for the quality, for the trust to the market. These are rather the financial supervisors. And with that being said, I think this is an argument which supports a limitation of the judiciary activism, because these are not the courts who are finally accountable for the quality of the market, for the level of consumer protection in the market, for the transparency in the market, and so on. If we include the courts in a broad market community or business community and agree that there will be a court which is also to some extent accountable for the quality of the market and for the trust in the market, for the competitiveness of the market, then we may also shift a bit the balance in terms of review. But as long as the supervisor remains the guardian of the market, then probably the judicial review of this decision should be limited. But that's like my view, and of course I'll be happy to discuss. So now I'd like to open the discussion for any other questions or comments that all the participants may have. Thank you very much. Yes, please, Andrea, please.
So basically, you stole my words, let's say, and I was just thinking that a chairman of this kind, I don't know if it was the right chairman for the session, but apart from that, I think that the problem is in substantive review is that you possibly, let's say, hinder the credibility of the regulator. So you must to build confidence, you must have an independent regulator, and you must play on the side of independence and authority rather than on review of decisions. And especially if you work backwards, let's say, if you allowed for substantive review, then at that point you would become possibly even the regulator a party of the possible proceeding. So and at that point that could be an easy, let's say, an easy excuse to make the regulator less impartial, so to say. I think it must be, I think, I'm talking about just a very general term. I think this must be seen in the institutional context. Of course, I don't know administrative judges, how they're appointed in every country. I think there's a traditionally, at least in the countries that have separate ordinary and administrative jurisdiction, once judges from administrative courts were less independent than the other ones, so to say. Now, for example, in Italy, it's not the case anymore, but the standard of review is slightly different in the sense that you look only at legitimacy, formal aspects mainly. So I think that there is a serious issue. If you allow for substantive review, then you may actually hinder the position of authority and independence of the regulator. So maybe you have a good outcome of the single case, but at a systematic level, perhaps it's not the case. Better to defer to the judgment of the commission, let's say, or of the regulator, in very general terms. But that's just a general comment. I'm not an expert on the matter.
Thank you. If I may add something to this. Two angles from which I would like to look at this legislative question, because it is actually a policy choice. Do we want to have it? One question maybe is the problem of access to justice really for the parties also, because the authority might impose sanctions that might be quite severe. And in Poland, and my understanding is the same in Serbia, at the administrative stage you don't really have a proper review. In Poland, for instance, you might submit the case for being re-examined by the same authorities. You do not have those two stages that you have in almost all other cases whenever you have administrative procedure, because you have like two instances, and here you don't have. So this would be the question number one. And another aspect, in many situations, the same factual basis could give rise to many procedures. So we might think of a situation, there is a violation of rules that make the market authority to impose a fine on the company. But the same set of facts might give rise to individual investors to sue for damages, and the same factual basis might trigger criminal procedures. So we might have three different procedures being conducted either at the same time or consecutively, but in a way non-coordinated. And this brings us back to this policy choice. How do we want to have this solved? And how much interrelation do we want to accept? Or also, do we want to consider the decision of one organ being prejudicial to the other? What should be the role of the Commission? If we agreed that there should not be substantive review of what the Commission did, should this be considered binding upon authorities, including court authorities, that where claims for damages are being pursued? Of course, criminal law has a different standard, but also in a way the same question might be raised. And taking all this into account, when we worked on this concept of capital market court in Poland, the question was basically, we are thinking how to make the most efficient use of limited resources. So we have a limited number of judges being able to properly understand the market and the entire complexity of capital market law. At the same time, knowledge of procedures is a less scarce resource, even though it is not very common. Maybe you have administrative judges being, perfectly competent when it comes to administrative procedure or judicial administrative procedure. We have civil law judges, but still the idea behind was somehow it would be still easier to have someone to be skilled in two different procedures. It is still easier to have such a person than to have someone to have a really deep understanding of the subject matter. So therefore our idea was to bring within our one institution judges whose key competence would be to understand the market and to understand the subject matter and the law. And if you apply one set of rules or another set of rules, it is not as relevant. What matters, what is the scarce resource really, is the understanding of the market. So this is like shedding some other light on the very valid question that you raise, whether it is as a policy choice we want to have this substantive review or not.
Follow up.
Yes, sure, please, Elena, go ahead, of course.
If I just may follow up, it was interesting for me actually that you talked about already and again today about this public department in the Specialized Capital Market Court, and that's why actually I addressed this issue at the end of my presentation, because I suppose that there are not so many cases actually. And when you speak about the procedural law, I would just give you an example of Serbia. What would happen if we were to accept that, for example, that solution? Because we already have commercial courts, which is very important. So we have them, and they apply civil procedure rules. But also, this is something which is sui generis in Serbia. We have some special procedure for something which is called economic offenses. And additionally to these special procedure, these judges also apply criminal procedure law, which is very interesting. And now if you would add this public department, it would be plus administrative procedure law. So it would be like 3 + 1 or 2.5, and that's why I said then it's all in one, and where is the borderline? Why only the capital market court? What is, for example, happening with the competition court? I'm aware that in Serbia we would have that problem. So why did you do that? You have commercial courts, you narrowed something, divided some competencies. And for the public department, I still believe that it is somehow natural to leave it in the administrative court if there is one, because I really believe that for these a low number of cases, a few judges may deal with that if there is actually a reason for applying more recently the substantial law. Because I completely agree with you, and that's I wanted to add that almost always, not always, but almost always, these disputes may also be raised before the commercial courts. Actually, in one of the cases that I analyzed, the administrative court and later on the Supreme Court of Cassation, they concluded the same. It was the price of the takeover bid. So the Securities Commission delivered a decision, and that decision was related to the liquidity pay period of the shares and the price of the shares, and who made the audit. Was it independent from the party or not? And the court said here it is not such a big deal, because later on the minority shareholders may dispute the price in takeover before the commercial court. And that's the point where I want to agree, and that's why I said maybe it would be the easiest way just to educate those judges in the administrative court, just to be more aware what is happening in the capital market law issues, and then maybe when it's really needed to apply some of these let's say, rules as a control of the Securities Commission. But this is really, again, I'm saying a low number of cases, and this is not, let's say, this is not even needed in the majority of cases, such as this one, as I said, with the price in takeover. So we should have confidence in the Securities Commission. So I would just comment on that at the end.
If I may briefly follow up. I think it is a very valid point that whenever we would ever consider establishing a specialized court, we need to have a foreseeable case flow, right? And only whenever we can foresee for quite some time ahead to have a constant workload, only then we can have a specialized court. Other than that, we just maybe should limit ourselves to educated specialized judges. And your conclusion was such one that you said it is not enough of the cases. But to be a bit provocative, maybe it is in a way a chicken and egg question. If you have no chances for a substantive review, then you wouldn't maybe go to the court in the first place, and then you simply don't have that amount of cases because there is nothing you can get. So we are in Austria, and well, don't take it maybe literally, but we are in Austria, Kelsey and Jelinek, the very idea of constitutional court, and they could also say, well, there are no constitutional complaints, so why should we establish a constitutional court? Well, there were no complaints because you didn't have a remedy proper, right? So there's always a question. Once you have remedy and once you have institution to look at this, then maybe a demand for this will just emerge. So therefore, chicken and egg question.
Yes, I understand, and I completely agree, but in Serbia there is a remedy. So the judges, they may use the substantial law rules, but they do not take the opportunity. So that's why I enlisted those reasons with the application of the substantial rules. So it is one of the reasons for the claim before the administrative court in Serbia, but it never happens in the court practice. And the reasons for that may be, and I believe that it is that the caseload is really high, and secondly, they are not specialized in these kinds of cases, and it's much easier to see, oh, there is no minutes on deliberation voting in the file, and that is what is kept happening in practice, although they may do differently according to the provisions of the law. But any of the cases, and I analyze all the one, didn't use that opportunity. So just to add that.
One kind of like Polish argument, probably to support your conclusion, or your, let's say, working conclusion, is that it may be also a challenge to define the scope of the remit of such a court, because if you have a securities regulator, security supervisor, or you have a takeover regulator, takeover commission, then probably you may think of a court that will be competent for the review of this decision of such a body, which would be then the capital markets court. In Poland, we have the integrated financial supervision. We are in charge of the capital markets, but also banking sector, insurance, payments, now there will be crowdfunding and all the other things that come to be regulated. And then the question is, okay, so once we establish the court, should it be a court for the capital market only, or also for the banking market, for the insurance market? If we do it only for the capital market, then it may be some sort difficult to understand why, for example, a bondholder or a person who, or investor in an investment fund company has the right to go to this court, while a policyholder doesn't have the right to use, or an insurance company doesn't have the right to go to this court. So this may be also a question of how do we define the remit of this court. And another question which is adjacent to this one question is whether this court should also be constructed as a court for individual investors or individual customers, because I know from last week that in Austria it works like this, but then in such a case this will become probably one of the most busy courts in the country. And maybe one more comment to Patricia's intervention on the cassation model or reformatory model of the review. What we think is that even if we come to the conclusion that there is a need for reformatory judgments as a result of the judicial control of the decisions of the KNF, because I can imagine situations where the court will come to the conclusion that basically there's no case because, for example, the time limitation that has expired and any sanction cannot be applied or a fine cannot be imposed because of the time limitation, and then such a matter probably could be ruled finally and decided finally by the court. But probably again this does not require the establishment of a specialized court. This can be a relatively simple amendment to the current provisions of the administrative court proceeding, which will then allow the court to issue a reformatory judgment and not only to reverse. So maybe this is something that's worth thinking of, but this does not necessarily require a new court being established in Poland.
So as a few issues were raised, to start with the question of the need of substantive review and whether the court is necessary or not, I do agree that the court is not the only solution. Yet I tend to believe that the need of substantive review, either in some kind of appellate instance that is different than just the pre-examination by the same body, or this reformatory review, the court is competent to do so, as here we touch the ground of specialization is, and whether the administrative court and judges of this court are able to make a reformatory judgment in the pretty advanced capital market questions. So that's the first thing, because the court is maybe not an answer, but the answer is how to provide this substantive review. And as in this current system where we have only the cassatory model, I would tend to agree that we have this models where the supervision, so the authority is the guardian and the court is the one who guards the guardian, but only in this formal aspect, to use this metaphor. And as also the coordination issue was risen, so I think that the kind of coordination should be applied, yet as we do not have a full picture of how such institution as a specialized court would work, so we cannot address how this relation between the administrative and civil cases would look like. Yet I can easily imagine the problem where we have the administrative decision, administrative proceedings where there is no impositions of fine or no penalty, yet the same case regarding the civil proceedings where investors get a kind of recompensation. So here it seems like win-win situation, but it is definitely not. So the certain level of coordination definitely has to be introduced.
And you're absolutely right, and I can easily imagine cases like, for example, you may have a case where there was a breach of the disclosure obligations related to the acquisition of a block of shares, and then on one hand side you have an administrative proceeding that may result in the authority imposing a fine upon the acquirer who did not disclose the acquisition, but on the other hand this may also translate in a dispute related to the resolutions that has been taken at the assembly of the company, which then may be invalidated following the finding that this disclosure obligations have been violated. But in practical terms, what I would expect from the court, from the civil court, would be rather to, I would expect the commercial courts to kind of like embrace the opportunity to have the pre-judicial decision of an authority or an administrative court, which means that what I would expect to happen in such a proceeding would be that the commercial court would just suspend the proceeding until the administrative decision regarding the breach of the disclosure obligation is final and unappealable, and probably only then would move on with the adjudication in the commercial case. But this is just like a gut feeling. But that's in practical terms how I would expect this to work. But you're right. The level of coordination is quite significant, especially on the matters related to capital markets, where this translates also into the validity of corporate actions and so on. Adek,
this example with violation of acquisition of substantial.
This example that you gave, it was precisely one of the possible illustrations of same factual basis triggering different procedures. And if we follow, as I understood you, if the civil court hearing the case brought by investors or by the company or shareholders, whether or not somebody could exercise voting rights, if the sanction of non-exercising those voting rights should be imposed because of violating those rules. If this court now, hearing corporate case, would wait until the other case is settled, and there you wouldn't have a substantive review whatsoever, and then the court would consider itself bound by this, then you will end up with a situation even for the civil law litigation with no substantial review whatsoever.
But we are not talking about no review of the administrative decision. We are just talking about the level of scrutiny. So of course there is judicial review. The question is whether the judicial review goes into the, for example, into the discretion of the authority. So I'm not of course I'm not advocating for a lack of a judicial review of administrative actions, but the question is what is the model, what is the philosophy of this review. And
but the empirical evidence suggests it is just a formal review, and we are just debating if we want to have more.
It is, but then there's the question, also a question of efficiency, because if you allow for substantive review, then in the example that we are using now, you have to take into account that it will take longer for the commercial court to receive some sort of a guidance on the of the interpretation of the interpretation of the public law provisions. So I can imagine arguments working both directions. And anyway, you always have to take into account that there may be a situation where the commercial court or some sort of a private law court will have to take its own decision. And now I'd like to use an example which I like, because actually this is something which illustrates the need for, which I believe there is such a need for a very specialized court, which will be a private law court. And this goes down to some of the presentations that we heard before about the injunction and interim reliefs, because a very interesting case is the one that may happen if one of the shareholders claims that there has been a violation of the disclosure duties, but prior to the resolution being taken. And then the question is what happened, and probably that's a case which would be a handbook case for an interim relief or for an injunction. But in such a case, of course, the private court will have to make the decision without having a chance to obtain any sort of a guidance from the financial supervisor. So probably there is some need of coordination, but there may be also cases where there will be no time for such a coordination. Okay, so now I would like to ask if there are some more comments or questions. Gentlemen, Jelena, Patricia.
If there are no, then
So
just moving to the very final point.
So thank you very much. Thank you very much, ladies. Thank you very much, Jelena. Thank you very much, Patricia. It was a pleasure to chair the panel. Now I will give the floor to Adek as the host of our conference.
I just wanted to thank you for chairing this session. The final one, I think, is always the most difficult one because everyone is already a little bit tired. This is a pandemic style of a lunch, a lockdown style of a lunch, so we need to accept what it is and look forward to better times in the future. So we are at the end of this quite unusual conference that lasted for an entire week. 2 consecutive Fridays, and I would like to thank everyone who contributed, speaker, chairpersons of the panels, but my special appreciation goes to my team, who, in spite of all the difficulties, I must tell you, we are extremely understaffed now. We have, like, roughly speaking, 60% of our normal occupation that we should have at this institution. So my highest appreciation and thankfulness goes to Olga, who made it possible and is with us all the time, to Paweł and Robert, who were responsible for preparing the stage here, everything from this technical side, and are the silent heroes of our event. Recording, making sure that everyone switches off and on the microphone, and yes, so that this have been streamlined on Facebook, on YouTube, and after some maybe adjustments will be put there and stay forever, so be careful. Jacek, I don't know whether Jacek is now around, and Kasia, without their involvement this would never be possible, so my appreciation. Now very few words concluding what we discussed today and past Friday. I don't know whether such a conference has ever taken place, but think of yourself now, just using our imagination, because we were using our imagination a lot, thinking about possible designs. So think of yourself being medical doctors and gathering for a conference if any kind of specialization is needed in the medical practice. I don't know what kind of arguments would have been raised if such a conference ever was taking place. Probably not very many arguments would have been raised against medical specialization. I think everyone feels a bit more comfortable going to a dentist whenever you have a tooth problem, and to a rheumatologist whether your knee is hurting. So I think it is something we are witnessing, and we will be witnessing in the legal field as well. I am very happy that we could have hosted this event, even though frankly, we have very limited credibility when we discuss about specialization. I briefly mentioned this last Friday, but I think it needs emphasized, and it also gives you some idea about the place we are in. So this is a foreign office of the Polish Academy of Sciences, one of several. We have similar sister organizations in some other capital cities in Europe. And if I look back just 1 month, so we hosted here last Monday a very nice event on martial law, anniversary of martial law in Poland, with interesting debate about how the Polish nation digested this experience that is now 40 years back. So quite different topic. Then it is less than a month, or around a month, when we had also 2-day conference on law and memory, genocide distortion, free speech, Holocaust denial, and this sort of topics, highly interesting, but so different from what we are discussing now. So I think it maybe takes away some of our credibility, of my personal credibility, when I advocate in favor of specialization, while doing quite the opposite most of the time. Also, this, and we should not forget, this is, I think, 9th, I should have emphasized this more clear, 9th conference in the, or the, I think, 8th or 9th in the series of Center for European Company Law event series, which is like a flying organization. It's a network that originated in Netherlands, but has also partner institutions in Italy, Sweden, Poland, and now it should go to Lithuania as well. This would not be possible without this our umbrella organization that is very critically important for networking, and that this news came to so many people here present and the ones who watch us. It would not be possible without the network of CECL. And this brings me to, I think, my final points. The book that Martin, he is not with us anymore, but when he was introducing Ivan, Ivan published his excellent dissertation in a book series that is not accidentally managed by CECL and published by Wolters Kluwer, Kluwer Law International, in the entire book series that is managed, as I am saying, by CECL. So the proceedings of this conference will be also published in this book series, and I think it will fill an important niche, because there is not so much written on this topic. And I think our conference offers us an answer. Why is it so? Because most of the time we are just talking about substantive law. There is a lot of unification or harmonization in capital market law, and also to a lesser extent, but also in a company law. So it is somehow easier that we address those issues. And when it comes to institutional design and enforcement, it leaves room to national states. I am not saying it is wrong. Maybe for a discussion it is even more fruitful, but at the same time more challenging, because our points of departure are so much different. We might be so far away, but we can also learn a lot. And I would like for this book to be a source of inspiration for all of us. And sometimes, whenever there are conferences and there is like a post-conference presentation, it is, I think, way too often a loose collection of essays just put together on a more or less random basis. And I would like to avoid this. I would like to be, even though it's a challenge, because our points of departure are so different, I think we should make effort to make it also more readable for the readers, and also more useful in any practical sense. So I will ask everyone, there will be a separate communication and so on, but just one thing I would like to emphasize, I will want to make sure that the draft chapters will circulate, so that everybody, before wrapping up her final chapter, will have a chance to go through the other contributions, so that we can make some inter-references, so that we have some internal coherence, so that we don't end up with essay collections that are just randomly put together just into one book. Because we might disagree, or we might still finding answers to many questions, courts or divisions or judges, but I think we all agree that we need specialization. Whether separate courts or in separate divisions, or just we need to have judges and make sure that the cases are allocated accordingly. but at least I think there is a common understanding and a consensus that the specialization is needed. The focal points of our conference today were sometimes different from what we discussed last Friday, but to those of you who did not attend the conference last Friday, there were also very important questions, practically important, but also constitutionally important. What is the dividing line between the legal knowledge that the specialized judge or court needs to bring to the room, and where does the legal knowledge end and the special knowledge begins, and then we ask expert witness, and those division lines are oftentimes blurred. And as we all know, and I think it is again common to our jurisdictions, if we have judicial guarantees for judicial independence for the judges, we lack similar arrangements for expert witnesses. And whenever we end up in a situation where de facto expert witness makes a decision that the judge simply follows, then there's a big risk, an actual threat to judicial independence, because the judge just follows what the expert delivered, and the expert, well, is somewhere on the market, might be subject to influence that should not influence the final judgment. So many questions. We certainly will not be able to be exhaustive in our efforts, but I very much look forward to what comes out from this our joint undertaking, and thank you for being with us and for contributing. And well, the conference is now officially closed. Thank you so much.